Live stream audio check. Well, good morning, ladies and gentlemen. It's 10 o'clock. Inquiry is now open. First of all, can I just check, can those at the back hear me? Can I see a wave from people at the back? That's good. Thank you very much. My name's David Wildsmith. I'm a chartered engineer and chartered town planner. I've been appointed by the Secretary of State to hold this inquiry and to determine this appeal, which is made by Persimmon Homes Severn Valley under Section 78 of the Town and Country Planning Act 1990, against a decision by North Somerset Council to refuse planning permission for a residential development of 60 dwellings, use class C3, with supporting infrastructure and enabling works, including new vehicular access with Moor Road, public open space, landscaping and infrastructure on land at Moor Road, Yatton, North Somerset. I'll just go through a few housekeeping points. For the benefit of those who are less familiar with public inquiries, I'm just going to explain. I've got a number of opening announcements that I need to cover first. In a moment, I'm going to invite those who are appearing at the inquiry and wishing to speak to confirm their names for me. I then need to clarify some of the documentation for the appeal. I'll then explain the procedure to be followed for the inquiry and the draft timetable that I've circulated. Finally, I'll set out the main issues for consideration in this appeal. That's going to take me around about 40 minutes all told. I am well aware that the Council is seeking an adjournment of the inquiry as a result of what it considers to be late evidence submitted by the appellant, and I'll hear submissions from the parties on that matter shortly. But I do want to move on through the remainder of my opening announcements first. I've got to properly open the inquiry at some stage, so it might just as well be now. So after completing my opening announcements, I'd expect to invite the representatives for the appellant and the council to make brief opening statements to set out the basic details of their respective cases. I'll then hear from those, those interested persons who've requested to speak. And following that, I intend holding a roundtable discussion between representatives of the council and the appellant to explore the council's current housing land supply position. The inquiry will then move on with the presentation and questioning of evidence from the main parties, council first, then the appellant. There are actually a few more important housekeeping points that I need to just go through as well. The first is to say that I'm grateful to the council for making the necessary arrangements to be able to hold this inquiry as a face-to-face physical event. But clearly we all need to be aware of the fact that as a country we're still not on top of COVID. I'd therefore ask as much as possible that everyone attending the inquiry continues to socially distance as appropriate, use the hand sanitizers that I know are around in this room. The council, I think, would prefer people to wear a face covering when moving around in this building, but clearly you don't need to wear one when seated or addressing the inquiry. Secondly, it's quite obvious for those of you that are here, but I just need to say that the inquiry is being live streamed on the council's website. It means for anyone who simply wishes to observe proceedings, they can do so from the comfort of their own home. So you only actually need to attend the inquiry if you're actively participating. And I would encourage anyone who's attending today simply to observe, to consider not attending on subsequent days, to avail yourself of the live stream so that we can keep the number of people who attend the inquiry to the minimum necessary. Thirdly, though, if for any reason any of the intended participants find that they are unable to attend the inquiry venue, please inform the council or the inspectorate's case officer as soon as possible. We'll then have to bring into action the arrangements which I know have been made for that person or persons to participate virtually. I won't spend any more time on that at present because it may be that we don't need to use that to any great extent. But can I just have confirmation from the council that everything is in order for us to have a Teams event if we need to?
Yes.
Thank you. Thank you. Fourthly, I need to have a brief word about emergency procedures. Is there a fire alarm test scheduled today? Does anyone tell me? No. If we do have an alarm, I can see a fire exit there.
Right behind you.
There,
Yeah.
yes. Where do we assemble, please?
Now, in the past, we've always assembled by the flagpole. Where Okay. So if you go out the main entrance, turn right, you'll see a car park in there. It's where you've parked your car.
Yes.
Sir.
Okay. Well, hopefully everyone knows where that car park is. Hopefully we won't have an alarm, but if one does go, obviously it's for real today. Or, is the one scheduled any day in the week? Does anyone know?
Yes. Friday at 9 a.m., sir.
Friday at 9. Okay. So there's a test then, but other than that, it's for real. Okay. Thank you. Final point on housekeeping matters. If anyone's got a mobile phone with them, please make sure it's either switched off or on silent whilst the inquiry is sitting. Thank you. So, I now need to take the names of those who are wishing to speak during this inquiry. So, who appears for the appellants, please?
Good morning, sir. I do. My name is Charlie Banner, QC. I'm instructed by Persimmon Homes, Severn Valley. I'm going to call the following witnesses, and I'll just ask them if they can raise their hand when I mention their name so you can see who they are. So, first up, subject to the application of the Council to adjourn the whole inquiry, is Mr Patterson Neild on private housing land supply, Peter Mansell on highways,
Thank you.
Mr Tom Clarkson on ecology, Mr Jeremy Smith on landscape and visual matters, and finally Miss Catherine Ventham on planning.
Okay. Thank you very much,
Thank
Mr.
you, sir.
Banner. Thank you. And for the council then, please.
Sir, good morning. I appear for the council. My name is Timothy Leader, Leader. I'm counsel, instructed by Richard Kent, who is the planning manager for North Somerset Council. And I shall call four witnesses. The first is Natalie Richards, who is the principal planning policy technical officer dealing with housing land supply. The second is Mr Jim Phillips, a chartered ecologist who will deal with ecology. Thirdly, Mr Steve Thorne, who is our strategic transport planning manager. And finally, Mr Michael Muston, who is the principal of Muston Planning and a chartered town planner.
Thank you, Mr. Leader. Can I say that in terms of the professional qualifications of your witnesses, I think Mr. excuse me, Mr Phillips were on his proof of evidence in the abbreviated form that I expect he would like them recorded in my decision, but the other three weren't. Can I ask you at some stage during the inquiry to just hand me a list with those abbreviated qualifications?
Yes, sir, I'll do that, and obviously when I introduce them, I'll make clear what their qualifications are. If I might just add one small point, sir, just to make sure we get on the right foot. I'm not seeking an adjournment, I'm seeking the exclusion of my learned friend's latest rebuttal evidence, and if that's not granted, then I shall have something to say about an adjournment, just so we're clear.
Okay, we'll move on to that, as I say, when I've gone through the rest of these announcements. Interested parties, I've been informed by 5 interested persons that they would also like to speak at the inquiry. Can I check that you're present, please? The first on my list is Councillor Steve Bridger.
I don't intend to speak.
You don't intend to speak? No, okay. Thank you, Mr. Bridger. Someone representing Yatton Parish Council. Can I take a name, please?
Yes, sir. My name is Christopher Jackson.
Sorry, Christopher?
Jackson.
Jackson. And what position do you hold with the council, please?
I am Vice Chair of Yatton Parish Council and Chair of the Parish Council's Planning Committee.
So Vice Chair of the Council and Chair of the Council's Planning Committee.
That's right.
Thank you. I've got a Tony Mullin.
That is correct.
Sorry, where am I looking?
I'm,
On screen. Right. I've just got a TM. I got you. Right. Thank you. Yes. You're representing the Yatton and Congressbury Wildlife Action Group, I believe.
that is correct. I am chairman of that organisation.
Chairman. Thank you. I must admit we've used Teams sooner in the inquiry than I was envisaging, so at least we know it works. So that's very helpful. Thank you.
Yes, that's good. Thank you.
Okay, Anne Hodgson, please. Thank you. So I've got you down as a local resident. Thank you. And John Cockram. Same. Thank you. Anyone else attending who wished to speak? No. Okay, thank you. the fact that you haven't said you want to speak at the minute doesn't debar you. If anyone else does wish to speak, I'm happy to hear them as long as it's not repetitive evidence that's put forward. If anyone else does want to speak, I would ask that you submit a statement or speaking notes in writing before you speak, so that the main parties and myself can have a copy of that in front of us when you do address the inquiry. Okay, thank you. I should have said, in terms of those who wish to speak, you're all opposing the proposal. So, thank you. Now, I should have checked a moment ago, and I was asking about the fire arrangements, whether or not there's an attendance list circulating today. There is, good. Can I ask everyone present then please to put your details on that attendance list? As I've just indicated, in the event of an emergency, obviously it would be vital that we know who's attending, so we know that everyone is safe. If you put your details on the list that's going round, obviously other people present may also see your personal details, contact details. If you don't want that to happen, then please put your details on a separate piece of paper and make sure that's handed in to me before the inquiry closes, and there'll be a fresh attendance list on each day. Thank you. So, notification letter. Mr. Leader, I have received a copy of the Council's letter of notification of the appeal and a list of those to who it was sent. Mr. Banner, has the appellant seen the notification letter and the list of people whom it's sent? Not vital. Let me know if you haven't. But in response to the various notifications, the Planning Inspectorate's received a total of some 76 separate representations. I'm not going to go through them, but I do have the list of them here, so I'll leave that on the front desk. If the parties can just check that and see if there's any names there that seem unfamiliar to either side. If they do, let me know, and I'll get the Inspectorate's case officer to email copies on to you. Okay. And related to that, have either party received any additional correspondence directly that you're aware of? Okay, thank you.
I don't know, sir, but I'll find out.
Okay, that's good. Thank you. I should say, of course, I've also seen all the representations that were made at application stage, and I will, of course, take all representations into account when making my decision. Now, in terms of the documents that have been submitted, I've received proofs of evidence from both main parties, together with 3 rebuttal proofs from the appellant's witnesses. Now, I've read through the proofs and the rebuttal proofs, but I haven't had the opportunity to go in great detail through all of the appendices and core documents. I'll therefore have to ask advocates and witnesses to direct me to the relevant documents as the evidence is presented and tested. I've also received a signed statement of common ground, setting out the matters on which the main parties agree and disagree. And for anyone following this inquiry online, copies of the proofs of evidence and other relevant documents can be found on the Council's website on the planning application page. I believe it's reference 19/P/3197/FUL. In addition, copies of the core documents, I believe, can be found on the Moor Road, Yatton planning inquiry page of the Council's website. So all documents and evidence should already have been provided. However, if you do intend to submit anything else, please let me know as soon as possible. Any such documents will need to be submitted in hard copy, but I'd also ask for an electronic version to go to the Inspectorate's case officer so they can be put on the Council's website. Inquiry sitting times. Now, the inquiry was originally allocated 5 days, although when we had the case management conference to discuss the procedural arrangements for the inquiry, it did seem that that was perhaps not going to be sufficient. I will return to that in a moment, but just running through how each day will proceed. On a daily basis, I intend to break for lunch for about an hour at a convenient point around about 1 o'clock. I'll review progress then. I'll take short breaks or adjournments mid-morning, mid-afternoon, as necessary, and of course I'll look to the advocates to find an appropriate break in proceedings for that. In general, I'd hope not have to sit much beyond 5 to 5:30 each day. Having said that, I am aware that we need to vacate this room by, at the latest, 4:30, so I think we need to aim for a 4 o'clock finish today, and I believe tomorrow as well, as the room is needed for evening meetings. To compensate, I would hope we could therefore start a little earlier on subsequent days of the inquiry. In addition, this room is not available on Thursday of this week, so the inquiry will be held at the Grand Atlantic Hotel on that day. And I understand that the live stream will only be available for the days when the inquiry is held in this room. Okay, so for those of you who may not be familiar with the rules relating to inquiries, I just need to explain the inquiry has two main purposes. The first is to enable me to obtain all the information I need to make my decision, and the second is to give all those who wish to speak the opportunity of a fair and open hearing. So in summary, the procedure will be as follows. In a moment, I'll set out what I currently regard as the main issues before the inquiry and any other matters upon which I wish to hear evidence. The fact that I may not identify a particular matter doesn't prevent it from being raised so long as it is a relevant matter. I'll then invite the appellant's advocate, Mr. Banner, to make a brief opening statement, 5 to 10 minutes or so, simply outlining the appellant's case, and then invite Mr. Leader to do the same for the council. This will help all present to better understand the basis of the main parties' cases. Having heard both parties' brief statements, I'll then invite those interested persons who've said they'd wish to speak to make their statement. Mr. Banner may have questions for you. I may also have some questions. When all interested persons have spoken, I intend holding a round-table discussion, as I said a moment ago, with representatives of both the council and the appellant to explore the council's current housing land situation and hear each side's views on whether you consider the council can demonstrate a 5-year supply of deliverable housing land. And following this roundtable discussion, I'll then ask the council's advocate, Mr. Leader, to call his witnesses in turn to present their evidence. As witnesses may be cross-examined by Mr. Banner. I may also have questions for those witnesses. And finally, each witness may be re-examined by Mr. Banner by Mr. Leader in order to clarify answers they've previously given. When the council's witnesses have been heard, I'll ask Mr. Banner to present the appellant's case following the same procedure. And Mr. Leader will have the opportunity to cross-examine the appellant's witnesses. And I'll also give an opportunity then for any of the interested persons, if they're still present at that stage, and if they've got additional questions they want to put to appellant's witnesses, that's fine. I'll hear them then, as long as they're not repeating matters that have already been put to them. Again, I may well have questions for the witnesses as well. We then need to have a discussion on any conditions which might be appropriate in the event that I decide that this appeal should be allowed. I'll return to that in a moment. It'll also be necessary to have a general discussion on the planning obligation, which I've so far seen in draft form. And again, that's another matter I'll return to shortly. And then on conclusion of those processes, I'll ask firstly any interested party, then the council, then the appellant, to make their closing submissions, summarising their cases for me. For the information of interested persons, there's no need for you to make a closing submission unless you feel you particularly want to. I should say that you can't raise anything new at closing submission stage. It's simply the opportunity to summarise the case that you've already put to the inquiry. So if you've just made a statement earlier on, haven't asked any questions or anything, it may not be appropriate for you to make any closing submission. I'll then establish whether there's any other matters to be considered before making the arrangements for an accompanied site visit. Excuse me. And having done so, I shall close the inquiry. And in practice, it may be preferable to hold the site visit before the final submissions are given. That will give the parties, the advocates, more time to finalise their submissions. And you may well have seen, those of you who've seen the draft timetable that I circulated, I did indicate that it seemed if the inquiry goes as I envisaged it could do when I put that draft timetable together, that we might do a site visit Wednesday or Thursday of next week, possibly have closing submissions Thursday or Friday of next week, and that could be by teams if the parties agree and if that's the most appropriate way of taking that forward. Okay. Excuse me. So, I said a moment ago, 5 days have been allocated initially, but it did seem more likely that a total of 7 could be needed. That's what I'd based the draft timetable on. Let me just move on to conditions. I said a moment ago we'll need to discuss what planning conditions might be appropriate if I was to allow this appeal. I need to make it clear to interested persons present that this is standard procedure. The fact that conditions will need to be discussed doesn't mean that I intend to allow this appeal, nor does it weaken the Council's opposition to the proposal. I may ask the witnesses questions about conditions when I hear their evidence, and in any event, I intend to hold an open discussion about conditions towards the end of the inquiry. Now, I've seen the draft list of 27 suggested conditions. Can I just check with the parties, are they still being worked on between the parties?
Mr. Will on my right says yes.
That's good,
Yes,
and I'm seeing
that's
nodding
great.
on Mr. Banner's side, that's helpful. I'll look through those as soon as I can and let you have any initial comments that I may have, so that you can consider my comments and take them on board as necessary in the next version of that schedule. I've also received a draft Section 106 planning obligation in the form of an agreement. Mr. Leader, Mr. Banner, what's the latest position on the Section 106, please?
Mr. Barney go first, and I'll throw that to you.
Okay.
It's in draft. I think the intention is to keep it in draft until we've had the Section 106 session, so that if you've got any comments, they can be taken on board.
Okay.
So then I ought to throw this in. There's just one matter that is troubling those who instruct me, and it may be something which is easily resolved. And it is that we are unsure as to the nature of the appellant's interest in the land. There was an option agreement. The option agreement becomes renewable after a first period which has expired. And what we are unable to determine, though it may be we're just not looking hard enough, is whether or not the option was in fact renewed. We don't know whether it was. If it was, just let us know and show us, and that's fine.
Okay, well, Mr. Banner, your side has heard what Mr.
Yes.
Leader has said, so I'm sure you'll action that and
We will.
take the appropriate
Yes.
action.
Yes.
Thank you. Okay, well, we'll obviously have a session on the planning obligation at the same time as the conditions session. According to the draft timetable I circulated, that was looking to potentially be next week, Tuesday of next week. I've also seen the SIL compliance statement, community infrastructure levy statement in relation to the planning obligation that's been submitted by the council. Turning to the site visit, I've already seen the appeal site and the surrounding area from the public highway, but I will want to carry out an accompanied site visit later in the proceedings, as I said a moment ago, ideally after I've heard all the evidence before I hear closing submissions. I thank the parties for working together to produce a suggested itinerary for the site visit. That's been very helpful. Obviously, if others want to suggest additional points, I don't know how widely the draft itinerary has been circulated to those interested persons, but if they can be informed of what is currently on the site visit and just see if they have any additional matters that they would like to cover, that'd be helpful. I don't think there's anything more other than just saying that I just need to remind the parties that the purpose of the site visit is for me to see the site and the surrounding area. It's not an opportunity for evidence to be presented. So I won't hear any evidence at the site visit, but I am obviously more than happy for people to point out physical features on and around the site that have been already referred to in your statements. So we'll have to, as the inquiry progresses, decide the most appropriate time to slot that site visit in. I'll say no more about that just at present. I also just need to say that only exceptionally will material received after the close of the inquiry be accepted. Turning to plans, I haven't seen a list of the plans upon which I'm required to make my decision in either the suggested conditions or the statement of common ground, but I have seen lists both in the appellant's statement of case and on the appeal form. So I was just going to say, for ease, can I just ask the parties to work together to produce and hand in a list of the agreed plans upon which I'm required to determine this appeal?
Yes, sir. The Inspectorate was copied into a letter from Barton Wilmore on the 11th of February, which you may have seen, which confirmed which planting plan we're relying upon. That letter speaks for itself. The 11th of February.
Yeah.
And so, sorry, I can't speak when somebody else is speaking over me.
I've not got that immediately to hand, but I will.
Yes, sir. If you'd like a hard copy, we can provide it. I think the 11-page note we got from Mr. Leader last night speaks to that to some degree.
Okay. Okay, well, as I say, if between you can actually produce a list and hand that in, that will be helpful. Thank you. Now, costs. No party so far indicated intends to make an application for costs. If that should change, I do need to remind you that in accordance with the planning practice guidance, as a matter of good practice, applications should be made in writing as soon as possible. I also need to remind you that I do have the ability to initiate an award of costs in line with the planning practice guidance if I consider that necessary and justified. I'm nearly at the end now, so I'm just going to run through the main issues as I see them in this appeal. So based on the evidence before me, and broadly as agreed at the case management conference, I consider the main issues in this case to be, firstly, the extent to which the proposed development would be consistent with the development plan for the area, and that will need to cover such matters as whether the council can demonstrate a 5-year supply of deliverable housing land, and the weight to be given to relevant development plan policies, and of course the overall planning balance. Secondly, the effect of the proposed development on the character and appearance of the surrounding area, and that will obviously need to cover matters of landscape and visual impact. Thirdly, the effect of the proposed development on biodiversity, ecology, and the natural environment. Fourthly, the effect of the proposed development in traffic and transport terms, and this, of course, is in particular in relation to the proposed access. And fifth and finally, whether any submitted planning obligation and planning conditions would adequately and satisfactorily address the impacts of the proposed development. And of course, in addition, the appellant's case will need to have covered any other relevant matters raised by the other parties or by interested persons. Anyone have any questions or points to make on my list of main issues?
No, sir.
Good. Okay. Good. Thank you. Right. I've reached the point now, having gone through my opening announcements, when I would ordinarily ask Mr. Banner to make the opening statement for the appellant and then Mr. Leader to do the same. I'll sound you out on that. I think there's still some merit in doing that before I hear any application that you want to make, Mr. Leader, just so that it sets the scene for everyone present. If you're content with that, we'll do that.
It's always a good idea, sir, to assist the tribunal. So if that would suit you, sir, that suits me.
Let's do that then.
I agree, sir. It may help you, though, to understand where we've got to first, if that helps, just so you can... What?
Correspondence passing between council. Mine was headed, I think, confidential. Certainly the words confidential were included in the letter, and I think those from Mr. Banner were without prejudice save as to costs. Now, of course, it's a matter for you, but I would suggest that what we do is we hold off discussing the matter I wish to raise until we've done openings, for that reason.
I'd like to say what I wanted to say before Mr. Leader interrupted, if I may, sir. So just to put this into context, I don't know, have you seen my email of last night? About 5:47, it was sent to Alison. You may not have done.
I did see one last night.
Yes.
Yes. Whether it's the one that you're referring to, I don't.
Because there's an issue about whether Mr. Leader had left a message, and
yes,
I clarified the position.
Yes, I did see that one.
Yes.
Yes.
So just to put the issue of the application into context, as you've seen, sir, we received, I think it was 4:26 yesterday, without any warning, an application to exclude evidence and or adjourn the whole inquiry. A densely worded, say 11-page application, which subsequent email correspondence copying inspector indicated the council had had in contemplation since Friday. We didn't even have time to print it before I had to get to the train. For reasons you know about, and I'm going to make public, because a lot of people might make inferences, I haven't been able to prepare as much for this inquiry as possible because my children have been in Kiev until yesterday. And they're still in Ukraine at the moment. And Mr. Leader was aware of that. So I haven't had the chance to really even look at this till this morning. Sorry, just give me a moment. And so I can't respond to that application this morning. I'm not in a position to do that. If the application is maintained, then we'll need at least this morning to respond in writing. I think it's only fair that we respond in writing, and also one has to have one eye on where this may go afterwards. That
I would like a response
Yes.
in writing. I've obviously seen the council statement, but I was in a similar position to yourself, Mr. Banner. I haven't been able to print it off, so I have no hard copy. So that would be something that I would appreciate having. That. Thank you, Mr. Leader.
So the reality is, if the application maintained, we're going to need at least this morning to respond to it, and the opportunity for somewhere to print it. I don't know if that's possible here. We would apply for the costs due to the timing, but that's a secondary matter. An open offer has been made to the council, and I've made clear it is an open offer, not in any way recognising any merit in the application, but in accordance with our desire to keep the inquiry moving. And the open offer is based upon, from our initial reading of the application, I do stress it's an initial reading because of the timing of it, it relates almost exclusively to net gain, possibly also to veteran trees. It doesn't relate to the habitats regulations assessment issues in relation to bats. And so with that in mind, in order to keep the inquiry going, the open offer that we've put to the council is we crack on with everything apart from net gain and possibly also veteran trees. We park those issues to be returned to later, and if the council needs it to be much later, if it's a month from now, whatever, so be it.
Okay.
We deal with everything else, and we proceed on the basis of Mr. Clarkson's rebuttal and the planting plan there, so there's no exclusions of evidence or anything like that. No new evidence is to be submitted by either party except the evidence referred to in the final paragraph of Mr. Lee's application, 2 and 3. So Mr. Clarkson provides the various particulars that Mr. Leader seeks, and Mr. Phillips is allowed to respond only to those particulars, not raising new stuff about bats or anything like that. No costs on either side. And what that would mean is that either by the end of this week or by early next week, we get through everything else. We then pause, come back, and I think if we just parked net gain and possibly veteran trees and not the whole of ecology, my judgment is we could come back in a day and do the whole thing in a day. There may even be elements of round table that could be done, but we do it as one topic-specific day, and then we close. And we can have a discussion, because I know there's actually 3 inquiries in this district back-to-back. I'm doing the next one, and there's a third one after that. So whether we're to do it on a Monday to try, or whether it have to be after that, again, that's a matter of administration, but it could be done.
Yeah.
So that's our open offer as a pragmatic way. The alternative, I'm afraid, is to adjourn today till lunchtime. We then deal with the application. In reality, that means we won't get 5-year supply done today. That'll be tomorrow. If there are any gaps because ecology is excluded altogether or deferred altogether, for reasons I've explained, I can't deal with things quicker than the timetable because I am playing a degree of inevitable catch-up, for which I apologise. And we just think that's not going to lead to a satisfactory inquiry. So that's the open offer we've made. The council hasn't yet indicated its position. But in any event, we'd say it would be helpful to open anyway, but I thought it was worth just communicating that so the council can mull over that open offer and you can consider whether it might bring a focus to the debate.
Well, thank you, Mr. Bennett. Mr. Leader, I won't necessarily ask you to respond to that unless you so wish to. Yes.
A good try on behalf of my learned friend. I will resist the temptation to deal with it now, but a couple of preliminary observations. First, Council attending a public inquiry is expected to be ready to proceed, come what may. Second, I was in Basildon yesterday dealing with the local plan. I didn't know my learned friend's difficulties about the Ukraine or Kiev. I was driving around the M25. I did glance at his email, but actually I rang him, as his chambers will confirm, to speak to him. And it wasn't to give brotherly comfort in respect of his particular difficulties. It was to address the particular point that having received a letter from Barton Wilmore at around about 4 on Sunday afternoon, it having been sent to those who instruct me at 4 minutes past 4 on Sunday afternoon, there was inevitably going to have to be the application that I make. Last point before we get on with things, it's this. My learned friend appears to think that it's absolutely fine to introduce into the appeal plans which are not part of the application, which replace plans which are formally part of the application. Well, that is a matter for you, sir, bearing in mind issues of fairness. And that is what I shall address you on. I am, if I may say so, just a little bit surprised that it hasn't occurred to my learned friend to make a formal application to amend the appeal proposals, because quite frankly, whatever was sent in on Sunday afternoon by way of a letter formally amending the appeal proposals is all very well, but actually whether those appeal proposals are formally amended is a matter for you. And it's that which I shall address you on. And as I say, I'm a bit surprised that my learned friend doesn't wish to make an application to formally amend his proposal, but since he hasn't and won't, I am compelled, actually, to make the application that I make. Because what I'm not prepared to do, on behalf of the local authority, is sit back whilst the appellants slide in fresh proposals, which are materially different from those which are part of the application, and just shrug my shoulders and say, oh dearie me, we'd better just get on with it then. So, sir, I'll elaborate on my proposal when we've completed openings, but I have to say, as I suspect you will have noticed, we entirely reject the characterisation that is being made of the Council's position in relation to this particular issue.
Okay, Mr. Leader, thank you. I was saying no more at the minute, but I will say one thing. Obviously, we will move on, and I'll hear the opening submissions. Can I just check with the parties your view? Clearly, we need to have a break, whether it be a longer adjournment. I will come back to that. But in terms of hearing, after I've heard from the main parties, the next thing would have been to have heard from the interested persons. Do you think it's still appropriate to do that before I hear Mr. Leader? I can see merit in that. That's really why I'm saying
I can
that.
too,
Yeah,
sir,
yeah,
but
yeah.
We'll hear from Mr. Leader.
No, sir. Had my learned friend not introduced matters in the way he did, I would have agreed with you. But actually, no. Having raised the issue, it needs to be addressed.
Do it then. Okay, yeah, we'll do that. So let me first of all, let me first of all then invite Mr. Banner to make the opening statement
Thank
for
you, sir.
the appellant.
One of my colleagues has got, I think, 11 more copies, hopefully, or a few copies of hard copies.
Have I got a written
or some,
version of
so
it?
I can if they can be provided to you and Mr. Leader and to as many other people who would like them, if there's anybody amongst members of the public who doesn't have a copy and would like a copy, please approach me in the break and I'll make sure you're emailed a copy or given a hard
thank you.
copy. I'll just wait a moment till those who are going to get a hard copy get them.
Thank you.
Thank you, Catherine. So, sir, this appeal relates to a site which has for a number of years now been allocated by policy SA1 of the Site Allocations Plan, or SAP, as I'll call it for short, adopted in April 2018, the plan period of which is 2006 to 2026. And unsurprisingly, given the allocation, the principle of residential development at the scale proposed, in the location proposed, namely what's been referred to in the evidence as the northern field, isn't controversial as between the appellant and the council. The issue of controversy relates to the access being through the remnant orchard, which now contains only 4 standing trees and which the council's ecologist, Mr. Phillips, now says shouldn't be considered an orchard at all. The controversy about the southern field, the orchard, stems from the late insertion into Schedule 1 of the SAP, at the request of council members, not on officer advice, of the following words, that the provision of an access road across the orchard will only be considered if alternative access arrangement can't be made and subject to a suitable scheme being agreed with Natural England. Now, so Schedule 1 isn't part of the bold text policy. Its status is supporting text, which the bold text policy says the council will take into account. And it's trite law, of course, that supporting text can't introduce mandatory criteria that are absent from the bold text policy. See the Court of Appeal's judgment in the Charkley case, which is well known. In any event, the provision of Schedule 1 relating to access is satisfied, and this is for 2 reasons. Firstly, alternative access arrangements cannot be made. Only 2 candidate alternatives have been put forward by the council. There's another which has been ruled out at limine. And as to these, access via Grange Farm Road can't be made because the public highway doesn't extend up to the boundary with the appeal site. And access via the putative redevelopment of the rugby club can't be made as that putative redevelopment is entirely inchoate. Now, we don't know where the internal roads are going to be or where the junction would be. It's not in accordance with the extant development plan, and it's several years off, even on the council's own case, and even allowing for its potential allocation in the future plan. It's not included even in the council's own highly exaggerated list of sites that are deliverable within 5 years. And secondly, Natural England haven't objected, and they are in fact in agreement with the shadow HRA put forward by the appellant, the Habitats Regulations Assessment, subject to mitigation being put in place early on. We may have a discussion about what that means in due course. An earlier application for a slightly larger development, also involving access via the orchard, was recommended for approval by the case officer, but was refused by members of the planning committee at the council in July 2019. And the reason for refusal for that development, sir, didn't allege non-compliance of policy SA1 or Schedule 1. The thrust of the objection related to density and alleged overdevelopment. The application, which is the subject of the present appeal, was subsequently submitted for a reduced amount of development, and the case officer again recommended approval, again indicated there was compliance with policy SA1, taking into account Schedule 1. And committee members again refused to accept their officer's professional advice, and this time, inconsistently actually with the earlier decision, that they added an allegation of a breach of SA1, as well as the allegations related to landscape and visual impact and ecology impact of quote, loss of trees, hedgerow and habitat, and associated policy conflicts. Now, the starting point for considering members' reasons for refusal is that in North Somerset, the effects of the national housing crisis are particularly acute. The claimed evidence base of the council's 5-year supply is conspicuously weak, and for reasons which we will hopefully explore today, depending on what happens this morning, the true position is a 5-year housing land supply of 3.2 years against a backdrop of persistent failure to meet annual requirements. I'll just add there, it's 3.2 rather than 3.3 in a rebuttal because one of the permissions is expired, withdrawn. One of the applications has been withdrawn very recently, which has just had an effect to remove 55 dwellings. So it's highly notable as well that the council doesn't include this allocated site in its 5-year supply. And that itself is an indication that the council accepts that if it succeeds in resisting this appeal on the basis that an alternative access should be used, the consequence is substantial further delay. And note, sir, that delay would actually take the delivery of this site beyond the lifetime of the development plan document in which it's allocated, because that is only, that lifetime has a limited number of years left, 2026. Notably, the Council's most recent Housing Delivery Action Plan cites delays in the planning system as a significant issue in relation to its housing delivery problems. That plainly sounds in this context, we say. The 5-year supply shortfall means that the most important policies for determining the application are out of date, and the tilted balance supply is subject to any protective policies in the framework which provide a clear reason for refusal. The tilted balance, we say, would apply anyway, even if there wasn't a 5-year supply shortfall, but we say the shortfall is so obvious we don't need to go there. Therefore, the provisions, because of the tilted balance, the provisions of Schedule 1 of the SAP, which were only ever to be taken into account for the reasons I've already mentioned, in light of the tilted balance, they can't now, on any view, constrain development if the adverse impacts of granting permission don't significantly and demonstrably outweigh the benefits of doing so. The habitats regs and the associated provisions of framework paragraph 182 don't provide a basis for refusal. Natural England, to whose views within their statutory remit must, as a matter of law, be given great weight, have agreed that the adverse effect on the site integrity of the nearby special area of conservation, from where a small number of greater and lesser horseshoe bats commute over the appeal site, can be ruled out. And Mr. Clarkson's evidence explains why they were right to reach that position. The 4 standing and 2 fallen veteran trees on the site have a prognosis of just around 10 years further life and are likely to fall during this time. Their ecological value is as dead wood. All the trees will be retained on the appeals site. 2 of them will be moved internally within the site to make way for the proposed access, 1 which has already fallen and 1 which is standing. Attempts will be made to achieve a live translocation of the standing tree, but given that these trees' ecological value is as dead wood, and given that they will indeed be dead anyway within 10 years or so, it doesn't ultimately matter in planning terms if those attempts to keep it alive are successful. What does matter, however, in planning terms, is that the still standing trees, particularly the tree which isn't going to be moved, which contains the highly rare orchard tooth fungus, they will be supported, i.e. stopped from falling over, so their otherwise soon inevitable fall will be prevented. And that's a significant ecological benefit, sir, because orchard tooth fungus can't survive in a fallen tree as the wood in a fallen tree isn't dry, and once it falls over it gets damp and the fungus can't survive. The new orchard trees that will be planted will provide an opportunity for the orchard tooth fungus to survive on the site in the long term, compared to the baseline when all candidate host trees will likely fall within 10 years. And the restored orchard will also have a range of ecological, landscape and visual benefits. It will be an asset for Yatton and its community. Biodiversity net gain calculations, which are the subject, or at least the principal subject indeed of the application to be made by Mr. Leader, weren't submitted with the application, and nor were they requested by the Council during the determination of the application. Biodiversity gain formed no part of the reasons for refusal. And there was some misunderstanding. I'll just add here, sir, in light of the application, there was some confusion in Mr. Phillips' evidence about whether it was. He describes them as a part of the reason for refusal. Ostensibly, we objected. The Council then abandoned Mr. Phillips' stance and said it wasn't part of the reason for refusal. You agreed in your note. And that's where we got to in relation to net gain. It only goes, that's the common position of the Council, yourself and us, it only goes to how much of a benefit we are. The net gain related provisions of the Environment Act 2021 don't apply to the appeal scheme. The Council's disproportionate focus on this issue is wholly contrived and an unreasonably made sideshow from the real issues in this inquiry. And I'll just add, sir, that you said there's no indication of cost. We did actually indicate in our correspondence on this we are going to apply for costs on this issue. In any event, the 3 main points of dispute raised by the Council in net gain appear to be, with the caveat that when I wrote this I still haven't fully understood Mr. Leader's application, but they appear from the evidence to be, firstly, factually misinformed assertions about the status of the northern field, in terms of its history as use, whether it's grazed, etc., the allocated development of which is in any event uncontroversial and form no part of the reasons for refusal. So we just don't see what the fuss is about in relation to the northern field. A suggestion that none of the southern field should be treated as an orchard. And thirdly, a reliance on a consultation paper on the issue of additionality. Can you rely on mitigation as part of the net gain calculation? If so, how? A consultation paper on that issue produced by DEFRA after the council refused permission, and which therefore necessarily falls outside the reason for refusal, and for which the consultation is still ongoing. We don't know whether DEFRA is going to adopt or not adopt or vary that proposal. The only landscape and visual expert evidence before the inquiry is that of Mr. Jeremy Smith on behalf of the appellant. He concludes that the overall landscape and visual effects of the proposed access road will be highly localised and focused on an area which is already recognised as being strongly influenced by the settlement of Yatton. It would be no worse in landscape and visual terms than the alternatives, and in fact, compared to them, would offer significant benefits, given in particular the restoration of the orchard, compared to the baseline where the 4 standing trees are likely to fall, as I said, within around 10 years, with no plan for succession. Both highways experts on either side agree that the choice of access road is safe and convenient and would allow for traffic satisfactorily to be accommodated onto the local highway network. So, sir, for these reasons, as will be elaborated in the inquiry, we suggest that the proper conclusion is the appeal scheme is in accordance with the development plan, or even if there were some non-accordance, the tilted balance applies, and the adverse impacts of granting permission plainly don't significantly advance to outweigh the benefits of allowing the appeal. So therefore, we will invite you in due course, sir, to allow the appeal. And that's the opening statement on our behalf. Thank you.
Thank you, Mr. Bennett. Excuse me. Thank you. So, Mr. Leader, can I hear the Council's opening submissions, please? Thank you.
Now, apparently, sir, I've been guilty of not speaking directly into my microphone, so if anybody is inconvenienced by my bad behaviour, just put up your hand and I'll try harder. Sir, Policy SA1 of the North Somerset Site Allocations Plan allocates the appeal site for housing. Why then does the local planning authority oppose this scheme? The answer is that the appellant has failed to comply with the full terms of the policy and the other most important and relevant policies of the development plan, with the result that the scheme would cause substantial harm to matters of acknowledged importance. Now, why is that? Policy SA1 allocates the site for 60 homes. However, the policy also requires proposals to take account of site-related requirements and key considerations which are set out in Schedule 1 of the policy. I had those words. Now, so you will probably have had the chance to look at the policy within the site allocations plan, and you will see that if one reads policy SA1, the schedule containing the following words, no development in the orchard, and the provision of an access road across the orchard will only be considered if alternative access arrangements cannot be made, and subject to a suitable scheme being agreed with Natural England. Should a suitable scheme not be agreed, alternative access arrangements must be made. Those words in the schedule are expressly incorporated by reference in the policy and form part of the policy. So, with that in mind, the appeal site comprises 2 fields. The orchard is located in the southernmost and smaller of the 2. New housing is therefore confined to the northern field. The second requirement of SA1 indicates an access road may only be built across an orchard if the orchard if, one, alternative access arrangements cannot be made to develop that part of the site which is not orchard, and secondly, the scheme of development is agreed with Natural England. Those requirements reflect the Southern Field's particular ecological value and its contribution to the setting and character of the village. So if I may add a few words there, I know that we have the pleasure of hearing from a landscape architect on landscape matters, and his evidence is of course entirely welcome and interesting, but this is not a landscape case per se. This is a character and setting case, and whilst landscape evidence is certainly not irrelevant, you will have seen from Mr. Muston's proof that actually the points we take are rather different to those taken by the appellant. But never mind, we can talk about that later. Continuing with my opening at paragraph 8. Taking ecology first, the particular value of the orchard derives from, first of all, the rich habitat provided by the surviving 6 veteran apple trees that make up the remnant orchard. The value of this priority habitat is enhanced by the presence of a priority species, namely the orchard-toothed crust fungus, which is only recorded at 20 locations within the UK. Secondly, the value of the orchard's hedgerows, trees and grasslands for foraging, commuting and giving access to roosts for lesser and greater horseshoe bats associated with the North Somerset and Mendip Bat Special Protection Area of Conservation. It is obvious that development which leads to the loss of veteran trees and the destruction, fragmentation or disruption of bat habitat will cause harm. That is important because other development plan policies, namely CS4, DM8 and DM9, restrict development that has such effects. Turning to the issue of the site's contribution to the setting and character of Yatton, notwithstanding the mess that has been made to part of the orchard recently by its use for the grazing of horses, Mr. Muston will show it provides a picturesque backdrop to the village approaching from the northeast along Moor Road. In particular, the southern boundary of the southern field is marked by a narrow, winding sunken lane bordered by a hedge and trees with a dense overhanging canopy. These features combine to create a small-scale, soft, enclosed and intimate interface between the town and country at the entrance to the village. The quality of this setting is enhanced by the site's relief, which rises gently to the northeast, contrasting with the flatter land of the moors. The slope of the land also reveals the remnant orchard, which is seen against the backdrop of the Grade 2 listed Grange Farm, with which it is associated. Further interest is added to this attractive rural scene by Stowy Rhine, which flows gently along the edge of the site and creates a sense of stillness and tranquility. Core strategy policy CS5 and development management policies DM10 and DM32 operate to restrict insensitive development which would harm this character. Now, against that background, and in accordance with the mitigation hierarchy of paragraph 180 of the National Planning Policy Framework, it is obvious that driving a road across the orchard, resulting in the loss of veteran trees and bat habitat, is best avoided rather than mitigated or compensated. In a similar vein, it might be thought sensible to avoid disrupting an intimate, attractive and characterful setting to the entrance to Yatton. Therefore, it is surprising that the appellant's strategy is to ignore the imperative to avoid harm to ecology and setting and try to mitigate or compensate for the damage they will cause. However, so far as ecology is concerned, Mr. Phillips will show that the scheme, which is part of the application at the opening of this inquiry, insofar as it can actually be pinned down, will nevertheless cause harm by destroying veteran trees, destroying other trees, damaging important hedges, causing the loss of grassland that provides prey for lesser and greater horseshoe bats and other bats, disrupting their foraging, commuting and access to a roost at Grange Farm. Turning to the impact of the scheme on the setting of the village, Mr Muston will show the opening up of an access from Moor Road by punching a hole through an important hedge and sunken road will disrupt, damage and urbanise an attractive rural scene. That is why policy SA1 restricts development in or across the orchard unless it is impossible to find an alternative means of access to the northern field. As to the issue of access, the appellant contends there is no alternative means of accessing the appeal site that would allow it to avoid developing a road across the orchard. That is palpably incorrect. Mr Thorne will show it is possible to access the site from Grange Farm Road across land which has obviously been retained for that purpose by Taylor Wimpey. That may create a ransom. There is nothing unusual about that. The appellant seems to suggest that the fact another house builder owns an access point means the site is undeliverable by them. Well, if they choose not to treat with Taylor Wimpey, that may well be the result, but it does not mean the site is undeliverable in terms of the MPPF. On the contrary, the fact that the optimum access is controlled by a national house builder tends to indicate it could be delivered in accordance with policy SA1 if the appeal is dismissed and the appellant walks away from what I understand to be still its option to purchase the land. Mr Muston will also explain that there is a realistic prospect of securing access through the adjacent Yatton Rugby Club grounds, which the appellant well knows because it met, if I may add some words there, it met the rugby club on site as is recorded in one of the planning committee reports, but it's rejected that possibility. Mr Thorne will show that this solution is also likely to be technically feasible. Faced with those difficulties, the appellants may argue it is nevertheless right to override policy SA1, and I should say other development plan policies, because the local planning authority cannot demonstrate it possesses a 5-year supply of land for housing. That is a bad point. After re-adopting the core strategy housing land requirement in 2015, it struggled for a while to deliver the requisite number of new homes. While small and medium-sized sites came forward, the key to boosting delivery was to unlock strategic allocations at the western villages. Thanks to the efforts of Mrs. Richards and her colleagues, and it has to be said, colleagues in the house building industry, those sites are now delivering new homes by the spade load. The result has been a steadily improving housing delivery test result, which now stands at 89%. As a result of that improvement, the council is no longer required to apply a 20% buffer to its calculation of the 5-year supply. Consequently, the figure of 4.8 years' worth of land it possessed at the time of the case management conference has risen to 5.6 years. Now, the appellant disputes this figure. However, the inquiry will be invited to prefer the evidence of Mrs. Richards, my witness. She has a deep and sustained knowledge of every site in North Somerset based on many years' experience of working closely with landowners, developers and their agents, the HCA and others, to bring sites forward. Her evidence is also unexaggerated, objective, careful and economical. It is focused on facts viewed through the lens of the relevant parts of the framework and the PPG. Prior to the latest housing delivery test results, she was prepared to concede a 4.8 years supply. Her evidence is reasonable. It is to be trusted. Frankly, sir, it will be interesting to compare the level of her knowledge and experience of what is happening on the ground in North Somerset with that of the appellant's witness. Let's see who has the best knowledge of what is going on here. There being no pressing or any need to allow this poorly formulated scheme to proceed, you will therefore be invited to dismiss the appeal.
Okay, thank you, Mr. Leader. Okay, well, let me just sound you, thank you for that. Let me just sound you out again about what we need to deal with now. I am very conscious of the fact that we've got 4 interested persons here who want to speak, and I did indicate through the Inspectorate's case officer that they would speak, I would hope that they would speak late morning. I still think it appropriate to ask them to make their statements now if the parties are content with that. I understand what you said earlier, Mr. Leader, but...
Almost immediately on my previous observation, which was I'm supposed to be helping you. And then I flatly contradicted myself by getting very cross. So, sir, having calmed down and recovered my composure, I'll be very happy to do whatever suits you best.
Thank you. Well, I think if we hear from those 4 interested persons, as I said earlier when opening, it may be that Mr. Banner has questions for you. It may be that I have questions for you when I hear what you want to say. But if we do that now, then we can obviously then reflect. I can either invite Mr. Leader at that point to make his submission, or we could have a mid-morning break and come back after that. But let's move on to that point. Mr. Jackson, I'd got you down second on my list after the councillor indicated he didn't wish to speak. So, are you in a position now to speak for Yatton Parish Council? If you just bear with me while I find the documents that I know were submitted. Just let me... Yes, when the Inspectorate's case officer asked for the statement that you were wanting to make, when I looked through what was sent through, it seemed to me to be a bit of a composite of a variety of observations made by the Parish Council at this and earlier applications on the site. Is that a fair reflection? Is that...
Yes, sir, that's exactly what happened. During the various iterations of this planning application, as a statutory consultee, the Parish Council has made comments at each stage. And because it's been a kind of evolutionary process with this application, what has happened is that the comments that we have made at each stage have needed to incorporate the previous comments as well. So
Okay.
as you say, we've ended up with a bit of a composite.
Okay, well, the easiest thing may be, even though it's a composite, for you to still read it out. I'm content if that's the way that you want to deal with this, and then obviously everyone present is fully up to speed with the Parish Council's views and concerns about this proposal. So, Mr. Jackson, if you'd like to present the evidence of the Parish Council, then please.
Thank you, sir. I should warn you, there's 7 pages of this, so...
If we crack on, we'll get there.
All right, I'll go for it. Thank you. This results from, in the first instance, the consideration of the amended plans relating to the application 19P 3197 FUL. It was resolved by the Parish Council that councillors recommended not supporting the amended plans for the application for the following reasons. The Parish Council have historically never supported the development of this site, and this set of amended plans do not include any changes that would prompt a change to this view. The one, access onto Moor Road and the road safety issues it presents, together with the lack of permeability onto the high street for any residents of the site, would create an isolated community. The detrimental impacts on the orchard, the area's ecology, the adjacent Grade 2 listed building and the gateway to Yatton are fundamental in the Parish Council's recommendations not to support the amended plans. They therefore wish to reiterate all the previous comments they have made for the development of this site as follows. So this comes back to the plans that were amended, and the comments that were made there were that the Parish Council cannot see any merit in this new application and conclude that the long-term future of the village cannot be compromised for the short-term benefits of the developer. The principal objections made under the previous application remain unaddressed and therefore are still applicable to this new proposal. The proposal would cause significant and irreversible harm to the rural countryside setting at the entrance gateway to the village along Moor Road, to the setting of the Grade 2 listed building at the Grange, and to the biodiversity and ecology of the orchard, a nearby bat conservation area and Kenmore site of special scientific interest, for all of which no satisfactory mitigation has or can be found. The access onto Moor Road was unacceptable, and this application should not be allowed to proceed unless access can be secured through the development of the rugby club site, which it is understood is progressing towards the planning application stage. The Environment Agency continued to object to this application because the proposal includes residential dwellings within flood zone 3. In light of many parts of the country currently suffering very serious flooding, obviously made at the time that we made these comments, this element of the site must not be compromised. Many of the evidence documents submitted have not been updated since 2015. This was an application in 2019, including flood, archaeology, travel and transport and energy, some of which acknowledge the negative impacts the development will have, and others, in particular the travel and transport plans, are no longer accurate. In 5 years, vehicle movement has significantly increased, and this can be evidenced by recent data gathered by PACT, Police and Communities Together, which is current and very relevant to the sustainability of this site. The site layout design will create unbroken stretches of parking with no footway. This is unsafe for pedestrians and cyclists and visually unattractive. The Parish Council also wish to reiterate all the previous comments they have made for development on this site, as they are considered to be just as relevant and applicable to this new application. So now we go back to December 2018. Again, councillors resolved to recommend not supporting the application for the reasons that the Parish Council wished to reiterate all the previous comments they've made on this application, because the fundamental issues that have been raised have not been addressed or amended. Councillors also wish to make a further point regarding the roads within the proposed plans. They are measured at 5.5 metres wide and have no suitable turning points within the design. The same specification has been a cause for considerable concern within the proposed development of the former Titan Ladder site, and it is therefore very unsatisfactory to be presented with the same design specification again. This presumably will require amendment. And previous comments on the development site, again, a recommendation not to support an application made in 2018. The Parish Council cannot support plans for this development site in any form. They strongly reiterate all their previous comments, which still fully apply, and in addition, it is clear that Yatton Rugby Club are now in negotiations for the development of their site, and this has a significant impact on these proposals for Moor Road. The site as a whole is outside the settlement boundary and of a size that is contrary to CS32, which only allows for development adjacent to settlement boundaries up to 25 dwellings. In particular, the Parish Council cannot condone any development of or access road through the orchard next to the Grange, and this is supported within the newly adopted Site Allocations Plan, April 2018, Schedule 1, and by the Natural England consultation comments. The development of the rugby club would provide alternative access arrangements, and this must be pursued. However, the development of the rugby club would also provide a far more preferable site within Yatton over the Moor Road site, which would blight the beauty of the landscape entrance to the village and the setting of the listed Grange so significantly and permanently. We'll then go back to an application that was made in 2016. Again, the Parish Council resolved to strongly recommend not supporting the application. The reasons given were that the Parish Council have very serious concerns regarding this proposed development, as of all the recent deluge of speculative planning applications, this has the greatest and broadest of negative impacts. Firstly, it is, as far as we are aware, the last in a series of development proposals to target Yatton, and therefore, in light of over 500 dwellings already approved by North Somerset Council, an unsustainable, unnecessary overdevelopment outside the settlement boundary. As the number of developments North Somerset Council has seen fit to approve in Yatton has increased, it is our view that the S106 that accompanies them will not provide the necessary mitigation for the negative impact they will cause to the infrastructure of our highways, education and health services. Although it's not as large as the others at North End, its position is of far greater significance. It is cited as an exceptional gateway to the village, which, as you approach its outskirts, sees the settlement of Yatton on a ridge and the inclusion of this housing will cause a damaging alteration to this rural pastoral landscape. The proposal is very similar in terms of size and location to the refused application on Brinsey Road in Congressbury, and can be easily correlated to a judgment in the Forest of Dean for a proposed size of 85 dwellings adjacent to a listed building which was refused in the High Court. The more specific reasons for objection to this particular site are principally on issues of the damaging effect to the adjacent listed building, its setting and ecology, the detrimental impact on the landscape and entrance to the village, the highways and access, drainage, and the loss of amenity of rugby club training pitches. In terms of the listed building and surrounding ecological, environmental and social impacts, the Parish Council strongly urged North Somerset Council to re-examine the case of the Forest of Dean District Council versus the Secretary of State for Communities and Local Government, case number CO 4852/2015, as there are very similar parallels to be drawn between it and the proposed Persimmon site. It was for the same number of dwellings and was also set adjacent to a Grade 2 listed building. The High Court judge concluded that the damage to the heritage asset outweighed other factors, including the lack of 5-year supply, and quashed the planning inspector's decision to approve it, siding with the Forest of Dean District Council's refusal decision. This should give North Somerset Council the confidence to turn down this application by Persimmon on the same grounds, especially as it has other additional constraints. The Grade 2 listed building, The Grange, and its present setting beside an ancient orchard, is part of a wider wildlife corridor, including an area of special scientific interest, and is ecologically rich. The orchard has a rare orchard tooth, Sarcodontia crocea fungus, only found in very old apple trees, and there are less than 20 cases of it nationwide. The wildlife corridor is an important habitat for greater horseshoe bats, and the submission by Yatton and Congressbury Wildlife Action Group gives a comprehensive and knowledgeable view of the importance and impact building will have on the wildlife and ecology of the site and its surroundings. The Parish Council, in their submission comments on the site allocation plan, have requested that the orchard be removed from the plan and deemed as green open space. The Parish Council consider its protection vital, and North Somerset Council should observe the significance and adhere to its own policies and those within the National Planning Policy Framework. It is considered that the proposed development is contrary to the National Planning Policies 12, 126, 129, 131, 132 and 133. Any attempts by the developers to argue that the substantial public benefit outweighs the harm to the heritage asset and its setting should be resisted. Yatton has substantially contributed already to the public benefits of housing with the 500 dwellings that have been agreed. On a local policy level, the proposed development is also contrary to CS4 Nature Conservation and CS5 Historic Environment of the adopted Core Strategy 2012, and as these policies were unaffected by the subsequent Core Strategy challenges, therefore carry full weight. They are also linked and are contrary to DM8 Nature Conservation within the Development Management Policies of February 2015 and Replacement Local Plan Policies ECH 11 and 13. In addition, DMP February 2015 DM4 listed buildings and its links to RLPP ECH4 listed buildings clearly state that development is expected to enhance the character and appearance and special interest of a listed building and its setting. It is inconceivable that building a housing estate within its setting can be deemed an enhancement. The Parish Council were very concerned that the rugby club were facing the loss of their training pitches as a result of this application. If they cannot be accommodated on an alternative site in the village, it would mean the loss of a thriving sports club that provides a much valued sport and recreation facility, which would also especially impact on young people. This would be contrary to adopted Core Strategy 2012 CS27 and DMP February 2015 DM68, Protection of Sporting, Cultural and Community Facilities, and the National Planning Policy Framework, paragraph 74. Turning to highways and access, Since 2002, Yatton Parish Council and partnership groups have undertaken several consultations relating to the management of transport through the village and the impact on the quality of life for residents. In 2002, the village character statement identified the volume and speed of traffic, the number of heavy lorries, and poor facilities for pedestrians and cyclists as major issues. Locations of concern were the High Street and North End Road, up to North End Roundabout. The railway bridge also, as there is poor visibility for accessing the main road from the station inclines, both for vehicles and pedestrians. North Somerset Local Plan also supported the evidence and concerns expressed within the character statement, saying there is an urgent need for traffic calming in Yatton High Street, where the pavements and road are narrow in places and the increasing heavy traffic endangers pedestrians. Cycling to school is discouraged because the roads are seen as hostile to cyclists and too dangerous, i.e. the B3133 running from Congresby to Clevedon and linking to the M5 motorway. Similar views were expressed in 2014 following a Partners and Communities Together road safety review, 2015 Yatton Federation of Schools Parents consultation, 2015 survey of 100 residents in the precinct in Yatton, and in 2016 the Yatton Neighbourhood Plan consultation. Following a traffic survey commissioned in 2014 by the Parish Council and PACT, the data showed that over the last 10 years there had been a 28% increase in the volume of traffic through the village, and the cumulative effect of housing development in North End would result in that figure being almost 50%. There have been no highways infrastructure improvements made since 2002, and as one North Somerset Council transport officer stated, congestion is the major problem for Yatton. In February 2015, North Somerset Council published the Sites and Policies Plan Part 1, Development Management Policies. In the transport section, Policy DM24, Safety, Traffic and Provision of Infrastructure, etc., associated with development, the aim states to ensure that new development will not prejudice highway safety or the operation of the highway network, and that the impacts of new developments are adequately mitigated. TC10 also states development will only be permitted if it is not likely to lead to an unacceptable degree of traffic congestion or to generate traffic that cannot be accommodated without seriously affecting the character of the surrounding area and can be readily integrated with public transport, cycleway and footpath links and bridleways where appropriate. Persimmon Homes are proposing at that point that 83 dwellings be added to Yatton Village at North End on land at Moor Road. A travel plan has been produced that relates to the footpaths and roads within the development, but has very little bearing on the transport, cycle and pedestrian infrastructures outside the development. The access to the site itself is on Moor Road, which is a very narrow lane with no footpaths, cycleway or street lighting. It is also a cul-de-sac where residents of the terraced houses on the high street who have no parking facilities leave vehicles parked on this narrow highway. For these reasons, we would consider that Moor Road has little capacity and is inappropriate as a vehicular access for 83 properties. The Moor Road junction with Kenmore Road to the north has no footpaths or defined cycleway. It's a narrow road, and observing the traffic movement over a period of 1 hour, drivers travelling both north and south position their vehicles in the centre of the road. Approaching the village, there is a bend on the road which restricts visibility of vehicles exiting from Moor Road. The speed limit on Kenmore Road is 60 miles an hour, and the 30-mile-an-hour limit is almost at the junction of Moor Road with Kenmore Lane. It has been observed by Yatton Speed Watch that vehicles travelling into a 30-mile-an-hour speed zone do not reduce their speed until they are well into the zone. This would mean that vehicles travelling at 60 miles an hour into the village along Kenmore Road will be travelling at significantly more than 30 miles an hour at the junction with Moor Road. For reasons of pedestrian, cyclist and driver safety along this stretch of road, we do not support this planning application. To the south of the junction of Moor Road and Kenmore Road, the highway is congested due to the parked cars left by commuters who do not wish to pay the parking fee at the railway station. A combination of parked vehicles, vehicles approaching the junction at speed with potentially an increase in the volume of traffic, including cyclists, makes this planning application unacceptable. Drainage and flooding. The report submitted by North Somerset Council Flood Risk Management Team are objecting to the proposed development sustainable drainage systems in their present form. It is imperative that all the recommendations made by the team are carried out and conditioned as described. It is also notable that the Environment Agency have highlighted that the balancing tank is located in flood zone 3, and this would compromise its effect during a flood event due to tide lock. This, together with the findings of the Internal Drainage Board when their consultation response is received, should also be compiled with due to the site's close proximity to flood zones 2 and 3. Finally, the Parish Council would like to point out to North Somerset Council P&R committee members that this site is one of those identified in North Somerset Council's Site Allocation Plan 2016, which has been described by the applicants, Persimmon, as having absolutely no correlation between the sustainability assessment of villages, sites and the allocations made in the plan. Therefore, the plan is unsound. They are clearly very critical of the entire sustainability appraisal process, which underpins how the site allocations have been made, and which heavily and unfairly overburdens Yatton in comparison with other service villages such as Long Ashton and Backwell. Surely, if even the applicants are questioning the basis on which this site has been identified, then it behoves North Somerset Council to refuse permission, particularly given the very similar situation and successful recent refusal in the Forest of Dean. That's the end of those comments. Thank you, sir.
Yes, thank you, Mr. Jackson. As I say, quite a comprehensive run through, going back through the history of the proposals for this site, but at least we've got the full view of the Parish Council, so thank you for that. Mr. Banner, were there any questions that you wanted to put to Mr. Jackson?
There aren't, sir, because the points either have been dealt with or will be dealt with by witnesses, but I've listened conscientiously. Thank you.
Thank you. Yeah, I don't think there's anything that I specifically wanted to put to you, Mr. Banner. As I say, Mr. Jackson, it's clear that some of those points that the Parish Council raised in a sense have been overtaken by more recent events, but I still felt it was helpful that you were able to put the Parish Council's view before the inquiry. So thank you for that. And can we move on then, please? The next one on my list was Mr. Moulin from the Yatton and Congressbury Wildlife Action Group. So just let me find your statement as well, please. Right, I have it. So,
Good.
welcome, Mr. Moulin. Would you like to give your statement to the inquiry,
Yes.
please?
If I may, rather than read it out, I'd like to just summarise the main points and some points of emphasis. Would that be acceptable?
Yes, okay.
Otherwise, there's a lot of background information there about our credentials, which I'm sure is going to be very of value to the panel. But here we go. So I represent YACWAG and its 300 plus members. And with the help of local residents, we created a nature reserve adjacent or opposite the Appellant site. In 2020, we planted an orchard in one of our smaller fields of the two with local varieties. And we were aided by our Vice Chair, who has had over 15 years experience of managing orchards in Kent. We've been surveying the bats in the locality since 2004. Since then, we've been undertaking our own research and helping others with theirs. We have been able to identify the important flyways between Kingswood, Cadbury Hill, the Appellant site, which uses Stowey and other adjacent reeds. Our bat group has professional and amateur bat ecologists with links to organisations and universities engaged in up-to-date research. And we aim to be ahead of the game with the new evidence on bat behaviour that is emerging, and a lot of it has emerged in very recent years. Currently, YACWAG is working with North Somerset Council, Natural England and Strongfox in providing mitigation for greater horseshoe bat at a site in Kongsbury, a groundbreaking project. The transfer of the land is almost complete, and the most critical component, which in this is cattle grazing or grazing by sheep for the benefit of the bats, and we're learning about the practicalities of this. It's not straightforward. We make some comments about net gain. YACWAG agrees with North Somerset Council's planning proof of evidence and the policy framework used. We also agree with its conclusion that since net gain is not demonstrated, the application should be refused or not allowed. We also agree with some of the findings of the appellant's ecologist. Importantly, that even low levels of bat activity should be regarded as significant. And it is, they state, difficult to estimate the bat numbers using the site. There are lots of reasons why that is the case with horseshoe bats. The North Somerset Amended Bat SAC SPD states and clearly sets out the requirements for greater horseshoe bat mitigation. And this is within Zone B, both of the most important zones, A and B, within which the site is located. Now, the key features and habitats, it states, should be retained and enhanced. There also should be sufficient land allocated for mitigation. And further, that appropriate bespoke measures be implemented at an early stage of development. Net gain is an important metric, and there's a lot about this I know you're going to be hearing about. It is a simple terms, a measure or test of quality, and this is our issue. If it is negative, and that is what the North Somerset Council states, then the implication is that the mitigation is inappropriate and or insufficient, and therefore not likely to meet the ultimate test that the mitigation will deliver beyond all reasonable scientific doubt. Can I just to conclude, if you can help me by trying to visualize the orchard at present, picture it now. It is a remnant orchard. It could be better, but nonetheless, it is still a site devoted to grazing and being an orchard. It's a rare relic of our local heritage. Its boundaries are intact, the trees and the hedges. There is a continuity of grassland grazing by sheep and horses, producing dung for bat insect prey. There are 6 relic trees. They have value now for the potential with the fungi, but at least one of them does have the rare tooth fungus. Greater and lesser horseshoe bats commute, forage and roost in the Grange. So the area is being used now. There is little or no light pollution. The site functions as it is. This is the baseline from which we must start examining other options. Now picture the future as seen and put forward by the applicant on paper. Hedge boundary is breached in several places. 2 relic apple trees are removed. The site is urbanized with its disruption of, as an amenity land. It's a mown orchard with no grazing. There's no evidence that I can see of specialised management required for the orchard and its management. The access road would reduce its site size. An artificial roost with limited lifetime and no guarantee of use is being proposed. There is likely to be light pollution. This is a compromise solution, an amenity area plus an orchard without traditional grazing. Its impact on bats for foraging, commuting and roosting, unknown. Finally, picture another option, sympathetic and more sustainable. The orchard restored with planting of, say, 54 plus trees, probably more, rather than the 34 proposed. Existing hedges and trees retained with enhancement to make them even better. Site size maintained without an access road. A specific grazing regime with sheep or cattle. And surely this is what net gain is in practice. And we have to look at the practicalities. A more certain future for the bats and the rare fungi and local heritage. Thank you, sir.
Thank you, Mr. Mullin. I do have to say that when I allowed you to digress from your written statement as submitted, I didn't expect there necessarily to be a fair number of things which I didn't spot within the statement. What I would therefore ask, you were obviously, I think, reading from separately prepared notes that you'd done for that summary. Can I please ask, this isn't the way I would normally do it, but I don't want to not be aware in more detail of those points that you'd raised when you summarised that. Can you send that through to the Inspectorate's case officer, please, and I'll ensure that it's circulated to the other parties as well, so that they have accurate notes of what it is that you wanted to put forward as your case. Obviously, the reason for the statement is so we don't have to take detailed notes when you're presenting your case. But if you then digress to the extent that you did, I'm afraid it rather defeats the object. So I say I don't normally invite written submissions of an oral statement afterwards, but I think on this occasion it would be helpful to all parties. So can you do that, email them through to the Inspectorate's case officer, please?
I will be very glad to do that, sir. Yes,
Thank
I
you,
will do.
Mr. Mullin.
Thank you.
Mr. Banner, any questions?
Just a couple, sir. Mr. Mullin, I've got 5 images of your face to look at, but I'm not quite sure which one I need to be looking at so that you can see me. There, okay, right, hello. Something in a sports bar, except having your face on rather than the football. Mr. Llewellyn, I don't know, do you have access to Mr. Clarkson's proof of evidence? It doesn't matter if not, I can read out a sentence.
I have read it several times.
Okay, well...
I haven't got it in front of me, no.
I don't think, if you feel disadvantaged when I read it out, please do say, but for those who've got it on page 19, the main proof, there's reference at paragraph 4.3.21 to the commendable work, if I may say so, that YACWAC has done at the Kenmore Local Nature Reserve, sort of the other side of the road. Yes?
Yes.
And what's said there is that there's a note at the entrance to that site, which actually I myself have seen, which says that new fruit trees have been planted there to provide future opportunities for the orchard truth fungus in the older trees there, a sort of succession plan. Tell us a bit more about that, if you will. What was the thinking behind that?
Well, the thinking is, obviously, when you're going about restoration and creating habitat, you always take into account what is around with you. We're also mindful that bats actually do like orchard as a high orchard is a habitat, very important for bats. So being right there on the corridor, we felt that would be a good thing to do there. We tried with species-rich grassland there. To be quite honest, that's a long-term project to try and establish that. It is actually a lot easier. It still takes time to plant an orchard. But the idea was actually we were anticipating the loss of that orchard. And therefore it's important that we sort of replicate and try and dovetail maybe what is lost, but the opportunity to do various things there. So yes, we're sensitive to that important corridor because that bit of land there is right on the Stowey Green access, right the way up to Clavering, right down to the Little River down at North End. It is an important back highway.
And particularly in relation to the fungus, the rationale of providing new apple trees, new orchard trees, is presumably to provide a degree of longevity to the fungus so that it doesn't die out when the old trees on your site fall over and become too damp inside to sustain the fungus. It's a succession plan. Is that the thinking behind it?
Well, yes, it's like a potential receptor site for the spores of the fungi, and that is correct. Yes, it's but it's also in an emotional sense for local people as well. To be the members of the community sponsored each of those trees. They came to help with the watering of the trees. And I think it's because people feel a sense of loss, the potential sense of loss, but to be able to actually, in a small way, because the area's only got 14 trees in that area, but it just shows you the potential for how many trees could actually go in that other area if there wasn't, say, like, for example, the access road going through it.
And then in relation to the appeals site, you made various comments this morning. You talked about the other option of, say, 54 or so trees on the appeals site as a new orchard without an access road. And you were talking about that a few moments ago.
Yeah.
That's not something, I mean, if Persimmon were to apply for the same development on the northern field, but for one of the two other accesses that the council would like to see instead, or the members of the council at least would like to see instead, that's not something that we could be required to do, is it?
Sorry?
It's not something we would have to do. And it's an allocated site, and the allocation doesn't mandate us to plant a restoration orchard on the southern field. It's something which we couldn't be required to deliver.
That's
right, isn't it?
I leave that. I'm not going to disagree or agree with you. I'd leave that to legal counsel because you're asking me a legal point. What I would say is in terms of what I understand as net gain for the ecology of that ecosystem, which currently works, is that it would be a disaster if there wasn't some cattle grazing and some degree of orchard planting in that area.
No.
But
that's not quite my point, Mr. Moolin, because you say, if I may, if you don't mind, on page 2 of your note, the current note, under fungi and orchard trees, you quite rightly say that the opportunity sensitively to replant the orchard shouldn't be overlooked, and restoration of the orchard would be an enhancement, etc., which we say absolutely, and that's what we're providing. What you seem to be saying this morning is, well, there's a better way of doing it, and what I'm just saying in response is that's a pipe dream. It ain't going to happen. Do you have any evidence to suggest it would happen if the appeal was dismissed?
I don't agree with you, because in terms of what I understand your planting scheme and everything there, the point I would make about that is, as I understand it, is that, well, let's put a question to you. Do you think an amenity area, albeit planted with apple trees, could actually provide the important foraging habitat necessary for a link, say, between the Stowey Reen and the Grange?
Mr. Mooney, I'm embarrassed. I'm not allowed to have views. But what I am allowed to do is ask questions. And I will ask it a second time.
Okay.
If I may, I'll ask it one more time. And then if you don't want to answer, that's fine. We'll just draw stumps. Do you have any evidence to put forward before the inspector that the alternative restoration orchard of 54 or so trees with no development in it there's any realistic prospect that will actually happen if the appeal is dismissed? Do you have any evidence to show that is the case?
I can't comment.
Okay.
I think, let's say no comment.
No. Okay, well, thank you very much. It's very nice to sort of see you in 5 different ways. So thank you.
Thank you. Thank you, Mr. Moolin. I don't have any specific questions. I would just ask you again to ensure that you send that summary note through to the Inspectorate's case officer. But thank you very much for your contribution, Mr. Moolin. I'm going to move on now and Anne Hodgson, please. Would you like me to refer to you, Mrs., Ms?
Anne is fine.
No,
Mrs. I'm a Mrs.
You're a Mrs., thank you.
Yeah. Okay.
Yes, would you like to give your
good morning.
statement, please?
I live on Moor Road in Yatton, and I ask that you refuse this development based on the access going across the remnant orchard for the following reasons. Persimmon have not done enough to find another access to this site. They were told they had to exhaust all our other avenues, and they clearly haven't done this. This orchard is within the curtilage of the Grade 2 listed farmhouse, The Grange. In the recent High Court judgment of the Forest of Dean District Council versus Secretary of State for Community and the local government and Gladman developments, the judge ruled that the damage to the building, to the listed building, took precedence over, amongst other things, the 5-year supply. The 5-year supply is not up for discussion here, as it is only the access that is being contested. There are many similarities between the proposed Persimmon site and the Gladman High Court ruling above. The Grange and the orchard, when you travel across the moors, forms part of the gateway to the village. This proposed access road and associated development is closer to the listed building than in the above Gladman case. This access road will impact the character and the curtilage of the Grange, causing harm to its setting. The listed building still has many features that pertain to the cider making of old, when the orchard was fully functional, and this is the only piece of undeveloped land left from the Grange. This is Yatton's history, and it would be sad if the relationship between the farmhouse and the orchard were lost. It is well established that there are lesser and greater horseshoe bats in both the orchard and roosting at the Grange. The reason they have such a high level of protection is because they are so rare. The proposal to protect the bats by not lighting the road will surely be undermined by the fact that headlights, possibly full beam, will be used by the vehicles using an access road across the orchard. This proposed access will cause unnecessary, irreversible damage to the local environment that cannot be replicated or compensated for. Out of the very small amount of specimens of orchard tooth fungus ever recorded in the UK, the orchard has the only specimen ever to have been found in North Somerset, and it only lives on the wood of old and dying apple trees. To the best of my knowledge, no fertilizers, pesticides, or chemicals have ever been used on the soil or trees in the orchard. A variety of animals have grazed under the apple trees for centuries. And this is what has created the unique biodiversity found in this ancient orchard. You cannot be sure that any of the mitigations suggested by Persimmon for the orchard part of the site will be successful. And once the orchard is lost, it's gone forever. So having read the North Somerset Ecology Proof of Evidence by Mr. Phillips, I fully support his findings. North Somerset Council have not refused the idea of houses on the training pitch section of the site. They have unanimously and repeatedly refused the proposed access across the orchard, because to access a development across an unlit 2.4 acre field is totally inappropriate when there are other access options available. Persimmon are only being asked to find an alternative access to the site, which North Somerset have proved there clearly is. In this day and age, with the need for more environmentally friendly solutions and the drive towards a carbon neutral Britain, it has never been more important to protect this ancient British landscape. This application cuts across all that environmental champions are advocating. So to allow Persimmon to build a totally unnecessary road seems to me to fly in the face of both public opinion and public interest. Thank you.
Thank you, Mrs. Hodgson. Mr. Banner, any?
I don't know, sir.
No questions?
Thank you.
Thank you. Again, I don't feel there's anything I need to specifically ask you on your statement, Mrs. Hodgson, so thank you for that. And I'll turn finally then to Mr. Cochrane, please.
Thank you, Inspector. I'm hopefully not last but not least, so I have a statement which I will stick to reasonably carefully. My name is John Cochrane. I'm the occupier of the Granary Moor Road, and I'm speaking on behalf of several residents neighbouring the proposed development site. We wish to oppose the planning application. This case is all about the access to the site. Persimmon's proposal to construct the access road with associated pavement, paths and children's play area represents a significant development of the orchard. The orchard part of the development site connects directly to the Nailsea and Kenmore's SSSI via Stowy Reen, a recognised wildlife corridor. The orchard, with its trees and hedgerows, is important to the SSSI. The removal of these hedgerows to gain access for a road would cause a serious decline in biodiversity. Hedgerows have been shown to be one of the most precious forms of habitat. They provide pathways, shelter, and sustenance for wildlife, while protecting the soil, cleaning the air, and absorbing carbon emissions. It is essential to protect the biodiversity in order to maintain the flight paths of the lesser and greater horseshoe bats. On any fine evening at dusk during the summer months, I can watch the foraging bats as they continually crisscross my garden. After reading Jim Phillips' ecological report, I doubt that this would be the case if the orchard were to be developed. The proposed access road exits onto Moor Road, a narrow country lane. As you drive down the lane, you are at the junction with Kenmore Road, where to your left there is a narrow bridge across the Stowy Reen. At this junction, when turning left across the moor, you are likely to meet oncoming traffic in the middle of the road, often travelling in excess of the 30-mile-per-hour limit towards the village. Traffic at peak times can exceed over 400 vehicles an hour, including HGVs. We are not aware of any plans to improve this situation. Therefore, it is totally unacceptable to allow vehicles from another 60 houses to exit at this junction. Our aim has always been to protect the orchard. We have always accepted that the junior rugby training pitches bordering our garden, which were used for grazing when we moved in 13 years ago, would one day be developed. But without the training pitches, the rugby club has limited potential, and the proposed Persimmon development is forcing them to move. Consequently, logic would suggest that there is a possible alternative access to the landlocked site without using the relic orchard. In the recently published North Somerset local plan, the orchard is shown as being outside the parish boundary, as it always should have been. Now, in the preferred options document, the rugby club site and the training pitches are allocated as a combined development for 160 houses. This whole sorry saga, which has been going on since March 2015, should be seen as an opportunity. It is the opportunity to use the rugby club's planning application to Yatton's advantage. It can provide an access to the Appellant site and will give future residents a safe route to the new school in Chestnut Park and the proposed Sainsbury's store in Arnold's Way. We fully support the very detailed evidence for refusal put forward by the North Somerset Ecology and Planning Advisors. We also endorse the robust objections based on local knowledge from Yatton Parish Council. The government's current environment plan states the need to, and I quote, put the environment at the heart of planning and development to create better places for people to live and work. I ask you, the Inspector, to reject this development, which would destroy the orchard and its prominent position as a gateway to the village from the moor. And thank you for the opportunity to speak at this appeal.
Thank you, Mr. Cockram. Again, Mr. Banner, any questions?
Same as before. No, thank you, but I've listened carefully. Thank you.
Okay, thank you. Again, I don't feel that there's anything I specifically want to put to you, Mr. Cockram, so thank you for your contribution to the inquiry. Right, ladies and gentlemen, we've gone on now to 5 to 12, a little bit later than ideally I would have liked, but I think it would be appropriate now to have a short break and then come back and hear from yourself, Mr. Leader. Could I ask that during the break a hard copy of that note be provided so that I can work to that when I hear from you? Thank you.
So if I may, just to be very clear for Mr. Leader's benefit and yours, though I will need, say, the time I've asked for, which may be beyond lunchtime now,
Of course,
we've got to.
yeah.
But the position that we would likely take in the submissions I need to draft will be the same as our offer. So the debate is going, effectively, what Mr. Leader will need to persuade you is that he should get more than what I've offered in my open offer.
Okay.
Yes, sir. Can I give you a list of documents so that when you come back, they'll be to hand and we don't waste time digging them out? The first thing you'll need is your note of the pre-inquiry meeting.
Yep.
The second thing you'll need is the statement of common grounds.
Yep.
The third thing you'll need to have flagged up is core document A2, which is a letter dated the 19th of October 2020. The fourth thing you'll need is the design and access statement at document A4 of the core documents. The fifth thing you'll need is the LVIA, which is document A6. You'll need Mr. Clarkson's rebuttal, and you will also need a letter of the 21st of October 2021, which was sent to the Planning Inspectorate by Barton Wilmore, which contains a list of the documents submitted with the appeal. If you don't have a copy of that conveniently to hand, sir, I can provide you with one.
That would be helpful, Mr. Leader. There may well be one in bundles that I have, but not immediately to hand, I don't think.
Thank you, sir. Then just to wrap up, you'll need, if you've not already got it to hand, a copy of an email sent on the 9th of February 2022 at 10:16 by Mr. Quatermain to Miss Richards of the Council enclosing their rebuttals. It is the appellant's rebuttals. Do you have a copy of that, sir? Because if you don't, I can get you a copy of that as well.
Quite likely not.
No, I fear that.
I'll say no rather than
well, I'll dig
not
that out
finding
for
it.
you too, sir. And then finally, what you're going to need to be able to lay your hands on are the following plans: Y12 to Y14. And there are 4 different iterations of those plans. The first date from December 2018 and December 2019. Y12 is December 2018, the other 2 are December 2019. They are the application drawings as originally submitted in relation to the landscaping works that the appellant is proposing. They were followed, sir, by further drawings submitted in August 2020. You'll probably find those most conveniently, at least Y12 at least, within the design and access statement. There were then, it appears, submitted, at least Mr. Clarkson appears to think so, a further set of drawings dated November 2020. They're distinctive because they include the Hoggen footpath right next to the Stowy Rhine, which my learned friend and colleagues decided to do away with when they submitted the 4th set of drawings, which are dated February 2022, and they are the ones which are not yet part of the appeal proposals, but which I'm going to ask you to decide whether they should be or not. Now, sir, if it would help you, I can probably, in the time we're going to have while we break, get those 4 sets of drawings, if you like, bundled up, so you're going to have them conveniently to hand. But
it would certainly be It would certainly be helpful.
Yeah, I
Leader,
thought it might.
Yes.
So that is all you're going to need to hand. In addition, you'll need my note and my application. And so, as I shall draw to your attention, there are 2 separate things within that document. One is a note. The other is an application. The note is quite lengthy. The application, I hope, is reasonably short. And it's the application that I shall be addressing you on, not the note. The note is there to help my learner friend and yourself, sir, understand the factual basis upon which the application is based, but it's not part of the application. And, sir, with that, may I conclude this invitation to you and invite you to take your break.
So
Yep.
if I may, just one thing, I've received a note which confirmed a thought I had in my mind. We might need a bit more than 15 minutes to put all those documents together.
Well,
Yeah, yes, I was going to say, we're now 12 o'clock. I was going to say at least 20 minutes, but
Yes.
even a little bit longer
yeah.
we could do.
Well, so all of those documents are referred to in my note. They're all called documents, or documents that are on your file and my learned friends file. If you need time to get them together, fine. But, sir, you'll need to have them to hand.
Yes.
Because I hope that you will find, when you've looked at them, the application is of some merit.
Okay. Well, I mean, is half an hour too much time for that? I mean, I'll have to be guided by others. I know that Mr. Leader's going to provide me with most of those. I'll get some out, but I'm going to have a bundle.
We're going to have to assemble them ourselves, so I'd have thought if we work on the basis of 2 minutes per document, then plus time to go and get a cup of coffee and go to the loo, then that's half an hour.
Yes. May I just make this observation, sir? Mm-hmm. You said at the start you needed to know which documents form part of this appeal.
Yeah.
And your pre-inquiry meeting note asked the parties to put together a schedule of plans, which hasn't been done. May I suggest that the time we're now about to spend sorting this issue out may be of some assistance to you, because you are going to need to know what this scheme comprises of when you come to make your decision. So, sir, what I think I'm probably doing is inviting you to tackle a problem we would normally have dealt with at the start of the inquiry, though I understand why we went on to interested parties. What I want to do is nail down what the application is, I beg your pardon, the appeal proposal is, then, having done that, make a short application. I'm hoping this is going to be helpful to you, sir.
Yes, I mean, clearly, I do need to know which, if I can put it in simple terms, which landscaping plan is before me for determination in terms of the appellant's case.
I mentioned, sir, that letter of the 4th, I think it was the 14th, the
whatever day.
Whatever date it was. It was actually one document missing from Mr. Leader's chain, but it's probably worth having that to hand too.
It probably is. But, sir, what I would observe is this. As I will show you, the appellants have seen fit to make formal applications to amend Y12 to Y14, and they did so, and those plans have a certain status, and sir, it is a matter for you to determine whether or not to accept amendments to this proposal arising from the letter sent by Miss Fenton on the 13th of February. Putting it another way, it's not open to the appellant to say without your permission, oh, the scheme has just changed. And let me make it clear, on the basis of the appellant's behaviour in submitting that plan as they did, there will certainly be an application for cost by this council.
Okay, let's draw that to a close now. It's just gone 12. I'll adjourn now. Let's resume at 12:30 then, please.
Thank you, sir.
Thank you.
See you then.
Well, the inquiry is resumed, ladies and gentlemen. It's 12:30. Mr. Leader, thank you for those bundles of plans. That's going to be helpful. I think I've got all the other documents that you suggested. Obviously, the core documents are in the same binder, so I'm going to need a little bit of time to shuffle between one and the other, but I think I have them all to hand. So I'll ask you to present your note as far as you want to, and the application then, please.
Sir, thank you. I don't want to present my note at all. I want to make an application. And the application arises, sir, because I had contemplated, obviously mistakenly, that in the light of certain observations made by Mr. Clarkson in his rebuttal, there would be a formal application to amend the appeal proposals. But I can take you to why I say that in a moment. That not being forthcoming, I had better say. So the purpose of this submission is as follows. Two things. First of all, it's vitally important to know what the content of the appeal scheme is. It's a detailed application, and when one reads the title, or rather the description of what the appeal is about, and there are multiple references to that in the papers, so I don't need to take you to anyone in particular, but you'll appreciate, so that one of the things the scheme seeks to do is provide you with details of landscaping and other infrastructure associated with the development. So you need to know where that landscaping and infrastructure is described, and you need to know what you think about it. And in order to see it described, you need to look at a plan. And secondly, sir, or rather further, you need to know how much weight to place on an important material consideration, which, as I shall show you, is the extent to which the landscaping proposal and the associated ecological components of it mitigate or compensate for the admitted harm the scheme will cause. And the further point, which is this: the statutory consultee, Natural England, has made certain observations on the scheme, and it's important that you should be informed, and indeed they should be informed, if what they have made observations on is not the same as that which you're being asked to determine, which it isn't, as I shall show you. So for all of those reasons, it is, as I say, vitally important to know what we are dealing with. That's the first point. Second point is, it's vitally important to ensure the local planning authority has a fair opportunity to address what I shall show you is a principal contentious issue in this appeal. And it cannot have that fair opportunity if, when it read the statement of case presented by the appellant, and then when it read its proof, it was misinformed as to the full particulars of the case advanced by the appellant, contrary to the inquiry's procedures rules, or Rule 1 in particular. We are entitled to know what their case is, because if we don't know what their case is, we can hardly be expected to deal with it, and that is unfair. So, there's a practical purpose in this application, which is to help you and Natural England, and there's a fairness dimension, which is to help us and local people who object to this scheme. Now, how does the first issue arise? Well, if you were to ask yourself the question, what is the original content of the landscape master plan, the planting plan and the planting schedule. If you'd say, what was the scheme as originally submitted? Well, so you would need to go back to the schemes that were submitted dated September 2018, which is the Landscape Master Plan Y12, and a planting plan dated December 2019, and a planting schedule dated December 2019. Why do I say that? Well, there is a letter dated the 19th of October 2020, which supplants them when it formally submits amendments to the scheme. But it's important to note that if one looks at Mr. Clarkson's proof of evidence and his rebuttal, and indeed his statement of case, the biodiversity net gain calculations, and indeed the scheme he is working to as a baseline, is the one that was submitted in December 2018, rather one dated 2018. And in fact, if you look at Natural England's observations on the appellant's proposal, you will see that what Natural England comment upon is the scheme dated December 2018 and 2019. Now, I'm not going to take up time taking to all of these documents. If any of this is contested, I can deal with it in any reply I make. But as a matter of pure fact, the scheme as originally submitted was a landscaping master plan dated December 2018, and then two further plans dated 2019, December 2019. So that's...
Yes, sorry, just so I'm clear, they perhaps stating the obvious, they've been bundled together for me there.
Yes.
Landscape 2018, planting plan December 19, and planting schedule December 19.
Yes.
Yeah, that's fine, I'll just
Yes.
annotate that, thank you.
That's correct, sir. And as I say, Natural England commented in making their representations on the appeal proposal, what is now the appeal proposal, on plans that are of those dates.
Yep.
Now, why does that matter? Well, because if we then go to our first core document, and I invite you, sir, to go to document A2. You will see there a letter dated the 19th of October 2020. And that letter enclosed an updated design and access statement. And that updated design and access statement contained various drawings. In particular, it contained the the August 2020 version of Y12. And if you're wondering whether I can demonstrate that to you, I think I can. If you go to page 51 of the design and access statement, which you'll find at divider A4.
Sorry, page 51?
51.
Yep.
And all of this is in my notes, and so I hope what I'm doing is just picking out some key points. But if you go to page 51 of the design and access statement at divider A4, you will see there a landscape master plan, which is dated August 2020. Now that plan in that document is formally introduced into the application by the letter of 19th of October 2020. No, because I'm not reading through the notes.
Let me just be clear, though, because I may need to revisit these points, Mr. Leader. So you say, I think I can see something at 11, paragraph 11,
Yes,
you've got there at the end
All right,
of
well,
that.
if it's going to help you, sir, and it's going to help a load of friends, let's try and
Yep.
be helpful. So if we look at paragraph 11 of my note,
Yep.
you'll see there that I refer to the letter of the 19th of October 2020, which is the letter at A2 of the core documents.
Yep.
And so if you look at the design and access statement, and also, as it happens, the LVIA that you'll find on the council's planning application website, but not the LVIA that's been submitted with this appeal, you'll see that the August 2020 version is in there too.
Can I be clear there? Are you telling me there's two LVIAs?
There's certainly more than one LVIA.
Okay. As I said at the outset, I haven't had the opportunity to go through all supporting documents, so just so I'm clear that...
Yeah. Oh, no, the LVIA has been updated at various
Okay.
times. Now, the point being, sir, key point being, that the scheme was originally submitted as represented in the drawings of 2018 and 2019, December 2018, 2019, is superseded in in October 2020 by reference to plans dated August 2020. So we immediately note the scheme has changed. Then we go to the proof of evidence and the rebuttal prepared by Mr. Clarkson to detect further changes to the scheme. Now, sir, if we go to the ecology proof of evidence first, and if it helps you, I'm now looking at page 4 of my note.
Yeah, bear with me for the proof of evidence. Yeah, okay, so ecology proof of evidence, page 4 of your notes.
Yes, so if you look at paragraph 13.
Yeah.
And you remind yourself, so what you've probably read at paragraphs 4.3.8 to 4.3.33 of Mr. Clarkson's proof of evidence. You will see that what Mr. Clarkson says in his proof is perhaps just a little bit surprising. Makes you sit up. Because Mr. Clarkson tells us at 4.3.9 that in January 2022, alongside Mr. Charles Banner QC, and I'm going to just summarise, it appears he went out on site with Mr. Pearce, an arboriculturalist, and they decided that it would be a good idea to change the scheme and to transplant one of the 6 veteran trees, dig up another one, which had collapsed, kill it off, I suppose, and move the hulk as well. They thought that'd be a good idea. And so they decided they'd change the scheme to that effect. Now, you're thinking, I don't know about you, sir, but I immediately thought to myself, well, I wonder where I find that proposal. And so the point is, you won't until February 2022, but we'll come to that in a minute. So just moving on from the proof of evidence, we then find submitted a day after the date that you stipulated for the submission of rebuttals, because we got the rebuttal on the 9th of February, you having stipulated it should be submitted on the 8th, and it's apparently being sent to PINS on the 8th, but never mind. We get the rebuttal a day late. And we read the rebuttal, and in particular notice at page 10 something a little bit surprising. If I could take you to page 10 of Mr. Clarkson's rebuttal. Do you have that, sir?
I'm just getting there.
Thank you.
Page 10.
Yeah, I hope what you're going to see, sir, is a sort of species rules section.
Sorry, is a...
Do you see a species rules section at the top of the page at the rebuttal? There should be some grey boxes, sir, if you're reading the rebuttal.
No. I'm in the rebuttal. I think I've gone too far in the rebuttal.
Yes,
yeah,
you need,
yeah,
I
have.
need you to find page 10, please.
Yeah. No, I found a page 10 in the rebuttal. It was page 10 of an appendix
Yeah,
in the
well, it's
rebuttal.
quite a big,
I've got there. Yeah.
quite
yeah.
substantial rebuttal.
Yep.
Could I invite you, sir, to read the paragraph which begins under the species rule 5 box? Just refresh your memory of what it says.
Okay.
Now, as I read that, I have to say I was a little bit confused. And the reason I was confused is best illustrated by taking you to the bundle of drawings I've handed in. Because if we start with the 2018 Master Plan Y12, we can see to the right-hand side, to the northeast of the access road, a sort of semicircular hogging path, which sort of contours out from the side of the road but doesn't run along Stony Rhine. So you're thinking, as I read the paragraph on page 10, one of the things that strikes me is there's said to be inserted by mistake into the appeal proposals a hogging pathway along the edge of Stony Rhine. You're thinking, well, I can't see a hogging pathway along the edge of Stony Rhine. I said, well, I wonder if it's in the August 2020 version. So I look at the August 2020 version, and one sees that there are some slight changes to the hogging pathways. Doubtless they produce some changes of measurement, but I still can't see a hogging pathway along Stony Rhine. So I'm thinking, well, perhaps I must be seeing things. But then I turn to the November 2020 bundle, and lo and behold, one sees a hogging pathway along Stony Rhine. And again, some changes to the hogging pathway to the left of the access road. Now, you're thinking, well, where the devil did that come from? And the answer appears to be that the appellant has produced a different drawing.
Sorry, produced a different
drawing.
Different drawing, yes, sorry. I
At
moved
some
my papers.
point, and decided to adopt it as part of their proposals. And the strange thing is, though, it's not part of the design and access statement that is included in the bundle of documents submitted by the appellant with the appeal. It's not part of the LVIA submitted by the appellant in connection with this appeal. It's not part of any document at all submitted by the appellant with this appeal. But Mr. Clarkson seems to think it's part of his scheme, because Mr. Clarkson decides to write his proof of evidence, it seems, based upon it. And we know that because in his rebuttal he tells us I've made a bit of a mistake. It appears I've been using the wrong plan. Right. The funny thing, though, is this. And I simply ask you, sir, to make a note of this, and we'll see what my learned friend's got to say about it. there are some B&G calculations made by Mr. Clarkson, and the first time he makes them is in his statement of case, dated September 2020. And, sir, the B&G calculations that he makes in September 2020 in his statement of case are based upon the December 2018 and the December 2019 versions of Y12 to Y14. And go back to my paragraph 11 if you want to in my note to see why I say that. So we see some initial biodiversity net gain assessment dated, based upon, I beg your pardon, plans that have been superseded, it appears to me, not once, but twice. Once formally, and the second time, well, I don't know, in Mr. Clarkson's mind, I suppose. And the surprising thing is, the B&G calculation statement of case, and that which presumably Mr. Clarkson relies upon in his proof of evidence and his rebuttal, don't change. Notwithstanding, it is quite obvious that there is a different layout in each of those three cases. Odd, you might think. Now, why does that matter? Well, if I could invite you, sir, to look at, first of all, the pre-inquiry meeting note that you issued. You will see under main issues at 4, the effect of the proposed development on biodiversity, ecology and the natural environment identified as a main issue. Well, that is altogether unsurprising, because if I could next invite you to look at the letter of the 21st of October 2021 sent by Barton Wilmore to the Inspectorate, you will see on the first page, at the second bullet point, it stated that one of the complex issues and matters upon which expert evidence is to be called and tested in cross-examination includes, second bullet point, ecology. A critical issue is the effect of the proposed development on ecology, and in particular whether the effect of the proposed access route through the orchard would be acceptable and or beneficial in ecological terms and in accordance with the habitats regulations, having regard to the consultation response of Natural England, with which, as explained in the ecology statement of case, the appellant does not fully agree. Expert ecology evidence will be called on this subject from Clarkson and Woods Limited. So we've got your pre-inquiry note setting out the importance of this topic. We've then got the appellant's letter 21st of October being very specific about the ecological importance of the orchard. Then we have the statement of common ground. And so you will note that in the statement of common ground,
I would if I could put my hand on it. It was here a minute ago.
I know the feeling, sir.
Is all I can say. If I can't find it, I'll just have to ask you to give me the appropriate reference.
Well, it's page 13, sir.
Page 13.
Section 8, matters in dispute. Paragraphs 8.3 to 8.5, I'll read them out, just to underline why it might be of more than passing importance that we get this issue sorted out. 8.3, whether there is significant harm to biodiversity resulting from the development which can be avoided by alternative access arrangements. 8.4, whether the development will deliver biodiversity net gain. 8.5, whether the appeal scheme would result in an unacceptable loss of trees, hedgerows and habitats, and the extent to which this would impact on the rural character. So you see, sir, you having identified the matter as a key issue in your pre-inquiry meeting, the appellant having done so on the 21st of October of last year, the statement of common ground having reinforced those points, and then you, sir, having reinforced the point yourself this morning as to the centrality of the biodiversity and tree issue. It is perhaps important we all know exactly how the appellant's scheme is to be configured so that we can work out the answers to those issues. Now, Mr. Clarkson, having noted at page 10 of his rebuttal that he's got things wrong, says, and I'll read, to clear up this error, and I won't bother reading out what the error is because you can read it for yourself, I therefore attach a revised landscape planting scheme with my rebuttal proof of evidence, Y12, Y13 and Y14, February 2022, which if acceptable to the inspector should be substituted as the planting plan for approval. So there we see, sir, that whether or not the August 2020 drawings or the November 2020 drawings are part of the scheme, and I say they're the August 2020 drawings, but my learned friend may differ, we now see that what the appellant wishes to do, and this is said formally in a rebuttal proof of evidence by Mr. Clarkson, is to substitute in for approval Y12, Y13 and Y14. Which is why I said I was a little bit surprised earlier on that there's been no application to do that yet. Because you will read there, sir, it's hoped that this proposal is acceptable to you, which is why I'm making this application, because I'm inviting you to find it's not acceptable. And the reason it's not acceptable is to be noticed if one looks at the February 2022 scheme and compares it with the December 2018 scheme and the August 2020 scheme. When I say the August 2020 scheme and the December 2018 scheme, I'm talking about Y12 for now, so let's just stick with Y12. Yep. What's changed? Well, a number of things have changed, and if need be, I can take you through this in some considerable detail. But let's just have a look at it. You'll see that the Hoggin pathway to the northeast of the access road, whether it runs along Stowe Rhyme or whether it does a sort of little loop it used to do, has gone. That's the first thing. There is a reduction in the amount of habitat, grassland habitat, providing bat foraging, amongst other things, to be lost. Clear as a bell. Second thing is, if you now look to the south of the road, you'll notice that there has been a reduction in the length of the Hoggin pathway that loops to the south of the road. Thirdly, one looks at the density of planting and sees the density of planting has increased somewhat. And you'll see this yourself in your own good time, sir. But if you look at the drawings Y13 and the schedule Y14, the density of planting has increased quite considerably. Next, whereas previously the appellant's proposed just to drive a road over the trees at G7, the two veteran trees at G7, and sort of call it a day there. The idea now is that the trees should be translocated to the south-west of the access road. Now, funnily enough, that, as I've shown you, was contemplated in Mr. Clarkson's proof of evidence, because he went out on site with Mr. Banner and they scratched their heads and thought, what can we do about what we've done here? I know, let's transplant some trees. What they didn't do at the time was provide us with a fresh plan that showed that. So what they've done now, in February 2022, is give us the plan which effectuates the change that Mr. Banner suggested to the ecologist back when the proof was written, but which form no part of the December 2018 scheme, the August 2020 scheme, or the November 2020 scheme. So we see in February 2022 the appellant slipping in the translocation of a tree, bringing across the hulk of another, taking out some hogging, increasing the density of planting, and I could go on, but I don't propose to, because if we end up having to argue about this at this inquiry, well, all right, I can ask Mr. Phillips to detail the further changes. I've identified the main ones. Now, why does that matter? Well, I have absolutely no idea, sir, which proposal the appellant proposes to suggest its biodiversity net gain calculations are based upon. Is it December 2018 still? Is it August 2020? Or is it November 2020? Because one thing's for sure, the calculation we found in the statement of case, which is the only calculation you will see, cannot be based upon the February 2022 scheme. And the reason for that is it is blindingly obvious the February 2022 scheme is entirely different from its predecessors. And the problem I've got, therefore, is I'm not sure which scheme is supposed to be part of this application anymore. But it would appear that whichever scheme it is the appellant says is the relevant Y12, and I don't know which one it is, it's very different from that which they'd now like to slip in for you to consider. Now, it appears that the changes the appellants would wish to work arise from a cock-up. That's fairly clear from Mr. Clarkson's very honest and straightforward admission on page 10 of his rebuttal. Well, all right, good for Mr. Clarkson. I commend him for his honesty, but quite frankly, the response to that mistake through the submission of the February 2022 drawings is unfair on the council. Why do I say that? The first thing is this. If, sir, you look at the statement of case prepared by Mr. Clarkson, you will see in his biodiversity calculations two things recorded. One is absolute change of habitat units and hedgerow units, and the other is percentage change of those two units. And you will notice that the absolute numbers are relatively small, but they produce a big percentage change. I don't know whether you've ever read Darrell Huff's book on statistics. It's got an evocative title to do with how to lie with statistics, as I recall. And one of the things that Darrell Huff is very keen to tell us all is you've got to watch percentages, because small absolute changes can produce big percentage changes. Of course they can. And therefore it matters, actually, that we know what the measured length of the various changes are, and how that is translated by calculation into biodiversity net gain. Because whilst Mr. Clarkson encourages you to believe, and Ms. Bentham in her recent letter of the 13th of February asserts the February 2022 scheme is materially the same as anything that went before. Well, one looks at it and asks the question, that's a little bit surprising, isn't it? And the reason it's a little bit surprising is not just the deletion of various hog-in paths and planting of extra trees, but it's also to do with the movement of the veteran trees and their retention within the scheme. And one asks the question, if it's also jolly immaterial, why is it the appellant is so keen to do it? What's the point? Why is the appellant insisting that the February 2022 scheme becomes the scheme? And I invite you to conclude that it must be because either A, it's discovered the 2018 scheme is not a very good scheme, or B, no matter how good the 2018 scheme is, it's not good enough, and it'd be far better to introduce the February 2022 scheme. Now, the trouble with that is, we don't know which of those it is, because we've not seen any measurements, we've not seen any calculations associated with any scheme other than the December 2018 scheme. So we don't know how August 2020 performs, we don't know how November 2020 performs, and we certainly don't know how February 2022 performs. But it does appear on the face of it that the appellants have sought to take advantage of a previous mistake by introducing a scheme which is materially better than anything that went before. And they now want you to simply accept it, sir. Now, to expect Mr. Phillips, on behalf of the council, to respond to questioning on biodiversity net gain is simply unfair in the circumstances. What is more, I can hardly test Mr. Clarkson's evidence and substance in relation to biodiversity net gain, because actually I can't take any instructions, because Mr. Phillips is in no position to instruct me as to the substantive content of his latest proposal. And furthermore, I've got no measurements or calculations to test him with. So I don't know how I'm supposed to deal with Mr. Clarkson in a substantive sense, although you can imagine where my cross-examination might go in relation to the way in which the whole thing's been approached by the appellant. By just reading my notes, I mean, it would take a while, but I shall be fascinated to understand how Mr. Clarkson explains the various aberrations and complications that I've alluded to in my notes. So, what is the correct approach? Well, the point is this. This is not just a case about biodiversity net gain, important though that issue is, as you've seen in the various documents I've referenced you to. Because what we're dealing with here is also directly related to the reason for refusal, which is concerned with the loss of trees. And given Mr. Clarkson's concession as to the importance of the veteran trees that the appellants were proposing to destroy, but now are not proposing to destroy, it is plainly important that we should be able to check, for example, whether there is any prospect of the transplanted tree surviving transplantation, because Mr. Pearce seems to suggest that it's a feasible thing to do. Mr. Clarkson, to be fair, explains there's some risk involved. Well, actually, we'd quite like to research that point and deal with it. Then we have this issue about whether it's a good idea to kill off the apple tree that's presently fallen but alive and dump its corpse somewhere in the vicinity of the transplanted tree. We're not actually told where that's going to be, because if you look at Plan Y13, dated February 2022, you see where the transplanted tree is going to go, but you don't see where the corpse is going to go. They don't tell us that, but presumably somewhere nearby. The other point is this, that the transplanted tree and the corpse are likely to provide valuable habitat, because you'll have read in Mr. Clarkson's evidence, for example, that these veteran trees contain holes within which bats can roost. So we just don't know how it is the appellants are going to calculate the biodiversity gain of moving these trees and keeping them. But plainly, the fact that they're being moved and kept does go to the question of how many trees are to be lost and what's the effect. And that bears directly upon the reason for refusal and, indeed, the relevant policies concerned with biodiversity matters, CS4, DM8, DM9 from memory. So it goes into both substantive harm and the development plan, and compliance with the development plan and indeed the planning balance. So these are matters of peripheral interest, no matter how much my learned friend may wish to portray them as such. These are matters which go to the heart of the appeal, and therefore it is wrong that the council should be ambushed on the 9th of February in the way it was by the submission of the late rebuttal. What is more, I would draw to your attention the fact that the council immediately wrote to the appellant's agent and asked them certain questions to help it grapple with what had happened. And it received a reply, as I said earlier, at 4 minutes past 4 on Sunday. I got the letter about 20 past 4. I've been unable to take any instructions on that letter. But one thing I can say for sure is that my ecologist has told me that he simply cannot deal with the evidence as it's now presented, because he just does not know how the February 2022 version of the landscape plan could possibly relate to the 2018 version upon which Natural England commented, and which was used as the basis for the biodiversity net gain calculations. So, how should we deal with this? Well, the simplest way to deal with it, sir, is for you to rule that we get on with things. I don't particularly want an adjournment, we're all here, let's get on with it. We get on with things, but the appellant is not permitted to introduce the February 2022 scheme, because quite frankly, it has behaved unreasonably in bringing it forward in the manner that I have described. Now, keep out the February 2022 scheme. I'm absolutely relaxed about cracking on, because I can deal with Mr. Clarkson on the basis of what he says at page 10 of his rebuttal, what he says in his proof of evidence, and what he says in his statement of case. No problem with that, because what I can do is show Mr. Clarkson that his case is actually based upon his statement of case. I can explain to him and ask him to agree why it is that subsequent schemes could not possibly be the same as that original version, and we can just get the whole matter dealt with. And there'll be no need to worry about evidence on veteran trees and bats, because of course the scheme will be that seen by Mr. Phillips when he prepared his evidence. But, sir, if the appellant is determined to introduce the latest scheme, what I'm absolutely entitled to insist upon is this: that we see set out in full measurements and calculations that explain and demonstrate, explain how and demonstrate that the February 2022 version of the scheme produces the same B&G as the December 2018 version. And I should like to see, please, evidence which articulates why it is thought likely the transplantation of the live standing tree at G7 is thought likely to be successful. And I'd like to understand what documentation in particular Mr. Parish relies upon in giving that view, because you'll have seen at Appendix 3 of the rebuttal, Mr. Pearce has got something to say about those matters. Well, I'd like to see it explained, please, and set out so I can ask Mr. Phillips to interrogate that information. And, sir, that then begs the question, well, if you're going to let the evidence in, what should we do? Because I've asked you to exclude it, but if you decide to let it in, what should we do? Well, what I don't want to do is this. I don't want to deal with biodiversity and ecology piecemeal. I want it dealt with in one fell swoop. So if you're going to let the evidence in, please, will you, sir, either A, adjourn off the whole inquiry, or secondly, in the alternative, and taking up my learned friend's suggestion from this morning, but modifying it somewhat, what I'd invite you to do is adjourn off the whole of the ecology evidence and go off to another day. The appellant can produce what it should have produced, give it to Mr. Phillips, Mr. Phillips can respond to it, and then we can come back and deal with it once. Because what I don't want to have to do is have Mr. Phillips give his evidence up front on part of the biodiversity and ecology case, then have to come back again to finish it off. That's a waste of our money, it's a waste of our time, and Mr. Phillips's instructions to me is that you simply cannot disaggregate the issue of veteran trees and bats from BNG. The two are interlinked. So if my learned friend has to have his evidence in, fine, but if you don't want to adjourn off the whole inquiry, adjourn off biodiversity and ecology, and let's come back and do it properly in one go. And if I may say so, sir, that appears to be a fairly reasonable and moderate submission. Of course, it proceeds on the basis, that second submission, that when the planners give evidence on the planning balance, we'd have to hold open the possibility that they would be recalled subject to the biodiversity evidence. But I suspect if both myself and my learned friend were to question the planners sensibly, that ought not to be necessary. So I'd be happy enough to have the planners give evidence, notwithstanding the fact that the planning balance does include issues of biodiversity and ecology. So, sir, to summarise, it's vitally important we nail down what the scheme is, and that the appellant, if it's to have the February 2022 schemes, introduces them formally and you accept them. That's the first point. Otherwise, it's not part of their proposals. Secondly, if we're not going to exclude the appellant's February 2022 evidence and what is set out in the rebuttal in relation to BNG and veteran trees, and that's my preferred, that is my primary submission, that you should exclude it. If you're not going to exclude it, sir, my second submission is either adjourn off the whole inquiry or alternatively adjourn off biodiversity. Now, if you said to me, Mr. Leader, are you really seriously asking me to adjourn the whole inquiry or perhaps just biodiversity? I have to say, sir, that since we are now at 1:20 on the first day, it's a bit late to be adjourning the whole inquiry off. I would be quite content that we adjourn off biodiversity as a topic. We might as well get on with it now we're here. We've made this level of progress. And I hope that goes some way towards a compromise which you will find reasonable if you're going to let the evidence in, contrary to my primary submission. But you will also need, sir, to give Natural England the opportunity to comment upon the latest scheme, and that seems to me to be a further factor weighing in favour of either excluding the evidence altogether or alternatively adjourning off. Can I assist you further, sir, because those are my submissions?
Okay. Thank you, Mr. Leader. I propose that we have an adjournment now. As to when we come back, I'll just have a word in a minute. But just a few points from myself just on this. I mean, thank you for the way that you've obviously gone through it. It's been very helpful and spelt out, as you see it, your alternatives. Obviously, I'm going to hear from Mr. Banner in due course. Just to, in some ways, state the obvious, I have a duty to make the most efficient use of inquiry time. And it's obviously very difficult to get this number of people together in one place at one time. So I wouldn't want us, unless it's absolutely necessary, to miss the opportunity of dealing with those matters that we can hopefully deal with whilst we've got everyone together. So I would hope that we could make as much progress as possible. And obviously the inquiry timetable has gone out of the window from day one, but we can bring it back on track in one form or another. The only other thing I do want to say, well, two more things I want to say, really. One is, obviously, I've followed all that you've said in terms of the difficulty of following which plans which, and obviously I'm going to hear from Mr. Banner as to which one the appellants want me to take on board as part of this appeal. But we do have the two biodiversity ecology experts together here. I wonder what scope there is for them to go away and work together to some extent whilst we're dealing with other matters throughout the inquiry to see what degree of agreement there may be. I can't foresee that, obviously, but it may well be very helpful if some form of statement of common ground on ecology matters can be put forward by the experts. And then, again, to state the obvious, what will then need to be explored is where there are differences. So that's what I would hope might be able to happen whilst we have the inquiry. I'll let you come back, Mr. Leader. My final point, though, is just on availability for coming back at a later date, if that is what we do. In terms of my availability, I'm available this week and next and the following week, but I'm not then available until week commencing the 4th of April, which may still be very early for those of you who I know are dealing with other inquiries almost back to back. But just to say that my availability would be that. If it would be helpful at all, and obviously if it's convenient for the parties as well, I would be prepared to sit on a Monday, whether that be a full Monday or a half day on Monday. So, you know, that would be something that we could perhaps bring into the balance there. I think that's all I want to say at the minute then. Yeah.
I've had a good opportunity to speak today already on this, so let me be quite clear. Fairness is key. What may be convenient from a learned friend and desirable from a learned friend is not necessarily so for the council. And whilst it may well be that conversations between the ecologists will lead to a degree of common ground that should already be set out in State of Common Ground, what I am entitled to insist upon on behalf of the local authority is that the appellant's case is set out with full particularity in accordance with the inquiry's procedure rules, and that has not been done. And furthermore, you will need, sir, to decide which scheme it is the ecologists are going to talk about, and you can't do that unless you've decided, first of all, whether this scheme goes in.
Of course.
So, sir, whilst I am mindful of the potential advantages of a high degree of consensus arising from proper discussion of the issues and a further statement of common ground, that should happen after we've decided which scheme is to go in and after the appellant's witness has furnished us with some information so that when we have a discussion about those matters, we do so on an informed basis, because I do not want Mr. Phillips to be under pressure trying to come to some sort of agreement during the course of this inquiry, feeling that he must do so, and thereby place at a disadvantage. Mr. Phillips is a reasonable man, and he isn't going to take hopeless points, but he needs to be properly informed as to the facts. And sir, I have to say, whilst I note the possible advantages of your approach, given the lack of clarity as the appellant's case and the obvious absence of measurements and calculations, I would respectfully suggest that wouldn't be the right approach in this particular case. As for when we come back, you will know, because my learned friend told you earlier, we've now got a run of inquiries which conveniently end around about 31st of March. So if you were to say, come back in the first week of April, absolutely fine. We could do that. But that's my response to no. I'm afraid what I would like to do, please, is ask you to either exclude the evidence or adjourn off ecology. But crack on then with the rest of this inquiry.
Okay. Yeah. Well, Mr. Barrett, I don't want to hear. Well, I do want to hear from you. I don't want to hear from you now.
Can I just make a couple of very short points?
Yes, yes.
First, in terms of time, the reality is we're not going to be able to respond today. If it would help you, sir, I can probably provide a written response for you to consider before we come back tomorrow, later today. I can't say.
Yeah.
I can try and give a time, but I'd rather just do it as soon as when it's ready, rather than commit to a time. And then the second point is there are two things missing in the chronology that Mr. Leader took you through, which I'm afraid to say mean you've been misled. And I'd like to point those two omissions to you now. I won't comment, but I'll just draw them to your attention, then you can reflect on them, and I'll save the comment for tomorrow. Firstly, could I ask you to take up core document CDB1, which is the officer report?
CDB1, just bear with me.
Sure. And it's page 21 of the officer report. And when you get there, you'll see proposed condition 12, which wasn't referred to in any of the written or oral observations.
Just bear with. Page
Sure,
20, you say.
Page 21, it's in the bottom right-hand corner, page 21, and then condition number 12.
Condition 12.
And that should say, notwithstanding the submitted landscape planting plan, drawing Y13, which is the planting plan, obviously, that's the centre of this discussion, and the planting schedule accompanying it, Y14, no development should commence until further details of a landscaping scheme, including full detail, size, species, and spacing, i.e. density, of plants and trees have been submitted and approved writing by the LPA to ensure a satisfactory landscaping scheme. I won't comment on that. You can probably anticipate what my comment might be tomorrow, but that may. I'm going to comment on that tomorrow. It is. Because on the council's own case, as recommended by the officer, these drawings did not fix their contents.
No, but you've missed out Y12, Mr. Banner. Where's Y12 referred to?
Mr. Leader, you're not going to cross-examine me.
Well, if you're going to accuse me of misleading the inquiry, you need to be careful. Y12 is not mentioned there.
The second point, sir, I wanted to draw to your attention, again, without comment, it was put to you the statement of common ground listed in matters dispute 8.3 to 8.5 biodiversity net gains, and the point was squarely an issue. We'll provide you, sir, with the draft, but the negotiations on the statement of common ground, we sought to add a section to the paragraph that mentions net gain. I don't have it for one of those three paragraphs, 8.3, 8.4, 8.5, which said biodiversity net, whether there would be a biodiversity net gain is a matter in dispute. We sought to add a, and the council's reason for why they're disputing this is ... And the reason we've done that is the council's statement of case contained the same bare assertion, and we didn't know. And the purpose of that was very much to try and understand what the case against us was, so that the experts could then have that discussion that you quite rightly, sir, are suggesting they have now to get to the bottom of what they agree and what they disagree. And anyway, that suggested amendment was struck out by the council. They refused to agree, pushed and pushed for it, but they refused to agree to it. So those are 2 points that I suggest. Without those points in the chronology, you do get a misleading picture. I'll comment on everything else in the written response. As I say, if it would help you to... I don't know what time Ms Dyson sort of stopped receiving emails, but is there a cut-off, or are they potentially, because I can't promise getting it to you before 5, I'll do my best. But
I can't speak for the case officer's time scale. I think certainly after 5 o'clock is still acceptable, but it would be sent to me first thing in the morning anyway.
No
so
problem. Well,
please send it at whatever time you're able
Absolutely.
to. Yes.
Sir,
Yeah.
this meeting's being recorded,
yes.
but I'd ask you to make a note, please, of what I'm about to say. I have been accused of probably one of the most serious offences a barrister can commit, which is to mislead the tribunal. So I'm going to invite my learned friend, when he comes to make his submissions tomorrow, to grapple with the following matter. When one looks at condition 12, which one bears in mind as a draft condition, one notices that the plan that we have been focusing on, namely Y12, is not part of that condition. Point 1. Point 2. We note that condition 12 is concerned with the submitted landscape planting plan and planting schedule. The word submitted may be an interesting one, because what it indicates is that the scheme does indeed include specific drawings. So leaving aside that we've not got Y12 here, but bearing in mind we do deal with Y13 and 14, would my learned friend like to tell us tomorrow, if he can work it out from his own client's drawings and letters, which submitted schemes we are talking about? Which plans? What are their dates? Where do we find them? Because that would be jolly helpful. But, sir, I reject entirely the suggestion you've been misled. And I would hope that my providing a full note was helpful to both you and my learned friend. And I would note this, that I could have simply polled up today, like many barristers do, and made my submissions in an extemporary way without providing any kind of note at all. And I've sought to help you and indeed my learned friend by providing a full note. And therefore, I have to say, I would rather hope my learned friend would feel able to withdraw what he said about my approach. I've been entirely open and transparent, and I hope helpful. And it's hurtful and frankly disrespectful to suggest that I've sought to mislead you. I have not. And I would hope, sir, that you can see that, even my learned friend can't.
So I didn't say Mr. Leader sought to mislead you, I said he painted a misleading picture. I stand by that.
Yep. Okay. Well, points are noted. I'm not going to continue with this anymore. Thank you. Right. We had to vacate this room by 4 o'clock anyway, as I said. It does seem to me that quite likely we've got a lunch and adjournment now. Does it make sense for us to just come back tomorrow morning? That seems to me to be the most appropriate way. Well, we certainly won't get it completed, not by my estimate, I didn't think. I don't know whether Mr. Banner needs anyone who's involved in that. Yeah. Well, he needs the time himself there. I think, in fairness, we've got to where we have. I'm keen to hear what Mr. Banner has to say. I don't want to sidetrack him any more than is absolutely necessary now, the rest of this afternoon. I accept that we're going to lose a couple of hours, which isn't helpful in the overall scheme of things, but obviously we need to know where we're going before we start going anywhere. So I think, but what time to start? This is the key. I mean, I'd certainly floated 9:30 as a general early start, and I had suggested if we're going on Friday that we do 9. Is 9 still doable tomorrow, or is that pushing it for everyone?
I don't see any shaking heads. I think Friday have to be 9:05, otherwise we're going to start with the fire alarm, aren't we?
Okay, well, I mean,
yes,
I understand we've got to
fine.
take documents out of this room to clear it for tonight. Yeah. Yeah. Well, I mean, all I need is access to them when I appear tomorrow morning to set them out again in the same way. I'll take a certain number away with me now to look through various things that have been said, but I will leave some of them here, so if they can be safely stored. I'll write inspector on the top of the boxes that I've got, and hopefully that'll be okay. But on that note, it seems sensible if I adjourn now and resume tomorrow at 9 o'clock to hear from Mr. Banner, for me to then consider, obviously give you a chance to respond as well again, Mr. Leader, and I'll sort of let that be exhausted to a reasonable extent. Then I shall have to form a view on what we're going to do, and if we're proceeding, then we'll just crack on with the housing land supply. I suppose that's really where I'm getting to. We'll try and get back on track with the timetable.
I hope I made myself clear. I obviously didn't. If the evidence isn't excluded,
Yes.
let's crack on.
Yes.
Let's.
Yes, I perhaps didn't phrase what I said particularly well.
I'm
Then
not asking you, sir, to abandon
yeah.
the inquiry.
No.
Not this far in. I'm just saying exclude biodiversity.
Yeah, understood. Yeah. Okay. Well, I'll adjourn then now. 13:37. I'm adjourning now. We'll resume tomorrow at 9 o'clock. Thank
See you
you.
then. Thank you, sir.